The judgment has been dictated, but will deliver it on order to keep it. My brother has to the judgment.
Mr. Naik, tomorrow it will be closed.
Yes.
Mr. Mahapatra, tomorrow at 10:30. Tomorrow it will be delivered.
Yes.
Sir. Yes, madam.
During the pendency of this, the legal state, this application has now been national benefit. Though the other is for recovery of 3 lakhs, but he has to get more than 6 lakhs.
I get funding for the mention about item 42. I am making mention tomorrow the content will be.
Inform the other side. Inform the other side that it will be taken up.
Yes.
Let us see, we'll take up. We have not applied our mind as yet. Let us see, we'll take up.
I have 2 matters, but these matters are relating to the special bench, Justice S.K. Padge and this upper. But last 2 months.
How can we tell us, that
Only your lordship can.
the amity and committee of the judicial discipline has to be maintained? You can mention the matter before the bench.
The bench is not functioning. That's the reason.
This you could have gone to one of the judge.
Mr. Sadegi,
You could have.
Mr. Sadegi, we have been impressing upon the bar that you most importantly the registered judicial or the registrar, they will place the record
This
for
special bench has already been constituted. Now it is within the domain of the bench when to sit and how to take up. That is what I say.
bench has already been constituted.
So you go before the senior judge, just apprise him of this fact. He may fix a date when he will sit. No difficulty.
My lords, may I mention a matter? My lords, this is for urgent listing of a stay application in respect of an MSME award. Now, what has happened, my lords, is this matter has...
Is it before this bench?
No, my lords, what has happened is it was listed before 3 separate benches. The last time was yesterday, and all 3 benches have said it is not to be listed before them because there's a confusion over the allocation. Because this is a writ petition challenging an MSME award.
So you
And we have challenged.
please approach on an administrative side. We will definitely
No,
see.
my lords, what has happened is the execution happens tomorrow, and I appear on behalf of Indian Oil. So therefore, the Justice Mahapatra has sent it back to my lords for urgent
Definitely take it back. Take it. Don't worry. It will be taken. The file will be placed with the administrative side. We'll look into it.
But would my lords consider listing it tomorrow, given the urgency, my lords? Because
We can't pass judicial order in the administrative side, sir. So let the file be placed today itself. We'll see to it that if it can be listed. Don't worry.
Oblige, my lords. Oblige, my lords.
Right. Case admission item number 2.
Challenging judgment dated 31/7/2024, this writ appeal is filed. But I have filed the writ application challenging the order of the disciplinary authority, appellate authority, and the revisionary authority. And
Compulsory retirement.
they have not removed me from the service. Subsequently, that was modified by the appellate
That's
authority.
true. That's true. And then the withholding of the increment.
Yes, Lord. They have reverted me to the lower stage and withheld all the increment, which is not contemplated under the rules, my lord, itself. Then I have, my lord, raised some points before the honorable single judge Not a single point was taken into consideration and no finding was given. Rather, your lordship may kindly turn to page 149, the judgment.
No, I'm looking at the judgment.
Yes, my lord. Your lordship may, if your lordship will come to page 151, then your lordship kindly paragraph subpara 1, case of the petitioner. My pleadings, some of my pleadings were quoted up to, my lord, page 156. That was quoted. Then submission of the behalf of the opposite party, that was quoted up to, my lord, page 160. Then your lordship may kindly come to the court's reasoning and analysis. Page 160, my lord. That only that again the version of the opposite parties were quoted and my case was dismissed, my lord. Not a single point I have raised before the honorable single judge has been, my lord, taken into consideration.
Sir, your salary was reduced to a lowest pay scale for 3 years.
My lord. Cumulative effect.
True.
That my humble submission here, criminal on the basis of a criminal charges, that disciplinary proceeding was initiated.
Sir,
I was acquitted honorably by the criminal court.
Now show us the criminal, because we are conscious of the M. Paul Anthony judgment. We are conscious of the GP Tang judgment. We are conscious. Show us that there is a parity. That's your duty to satisfy us or convince us on those proposition of law.
Miller, your
You
Lord,
know the scope of the writ so far as the disciplinary proceedings are concerned. Very limited.
Miller,
Recent
Sure.
decision, recent
this year the
decision,
review power.
Mr. Recent decision
Yes, yes,
on
I have
this
seen.
line,
Yes, sir.
Jaipal case has been distinguished.
No, Miller, your lordship.
Jaipal case has been distinguished in 2 terms.
Maharana Pratap Singh versus State of Bihar. This is of 23/4/2025. Here also taking into account that GB Tank case, so also that Ramlal case, the Honorable Appeals Court has held that once a
Sir.
person has been acquitted from the criminal charges, if on the basis of same charges the disciplinary proceeding.
Oh, there is no difficulty. The first and foremost judgment is the M. Paul Anthony.
Anthony.
That is the first judgment on
Yes,
that. That says that if the disciplinary proceedings and the criminal proceedings are on the self-same charges,
Yeah.
dependent upon the same set of facts, dependent upon the same evidence to be adduced, same witnesses to be examined, then in that event, if that criminal proceeding ended with acquittal, that's an empalentary, then it will impact that is DP proceedings as well. But GP Tang made a departure and says that mere acquittal will not do. There should be an honorable acquittal. And what is the honorable acquittal has to be subjectively viewed.
In 2011.
So please look at that. It can't be done that since you are exonerated.
That is one of the points. Your lordship may kindly talk to page 146. 146. Annexure 6.
What for?
But 146,
Yes.
I have raised the first point before the Honorable Single Judge that the proceeding was initiated and concluded on the basis of draft charges. That was my first ground law. That has not been taken into consideration and that has not been, no finding is there. Then next ground I have taken that there is no evidence.
You were served with the article of charges.
Milord,
The article of charges were very explicit, very clear, unambiguous,
Milord,
conveys what they really want to say.
Milord.
So in that event, if was no ambiguity, can you fall back and say that the article of charges were not?
Saying that articles are ambiguity or any other thing. My humble submission that charge sheet itself shows that the charge sheet, draft charge sheet is issued. They have indicated in the charge sheet itself, Milord.
Oh, the draft charge sheets are prepared, approved, and then the articles of charges are framed. That is what is the normal procedure in a disciplinary proceeding.
Go down to
Unless the
the
draft is prepared, nobody can. It has to be weighted and approved.
Milord, when they have issued it to me, they have specifically indicated this is the draft charge sheet, Milord. On the basis of a draft charge sheet, they cannot initiate the proceeding and conclude the same, Milord. Charge sheet has to be issued.
Why you participated?
Milord?
Why you participated?
No, Milord.
You could have challenged on the very first.
Participated and
could
exonerated
have-
by the
you have-
inquiry official.
Yes, that is, then you are very happy, then you did not raise that point. The moment the disciplinary authority dissented
Miller,
and say, no, we are not accepting the inquiry, which they can, that is within their powers.
Miller.
It is not the law that the disciplinary authority has to accept the inquiry report. They can dissent.
Yes,
They have to provide a reasons
Yes.
that for these reasons we are not accepting. They provide it,
Miller,
given you a further chance. You participated.
Miller,
And then that is what I'm saying. What is the scope of the writ jurisdiction
Miller. That
in the disciplinary proceeding matter?
Miller,
How far the court can enter, how far the court should not enter.
Miller. Your Lordship, kindly, I'm only pressing two decisions, Miller, two paragraphs. Your Lordship. First, Your Lordship, kindly see that 2000. না দুটা কপি দিয়েছি 2007 1 SEC L&S page 292 मिला
Yes.
paragraph 19 मिला
Yes.
when an employee मिला when an employee by reason of an alleged act of misconduct is sought to be deprived of his livelihood, the procedures laid down under the sub-rules are required to be strictly followed. It is now well settled that judicial review.
There is no quarrel to this. Is the most fundamental, I think, is the first principle in the service jurisprudence.
Miller.
That the non-observance of the principle of natural justice, acting dehoves the statutory
Miller.
provisions, and if something is done in excess of the power not vested in him,
Yes.
definitely
Then
court
here,
can,
Miller,
there is no difficulty.
Miller, here it is another thing has been said. It is now well settled that judicial review would lie even if there is an error of law apparent on the face of record.
This is what I am saying.
Miller,
Error of law means what?
Miller,
Error of law
Yeah.
does not mean an error in decision.
No, I'm not saying my humble submission.
So error of law must be that what is the principles of law or the fundamental principles of law having not followed.
Yeah.
Obviously,
Yes, sir.
there is no difficulty.
Miller, none of my points I have raised before the honorable single judge that has not been considered at all, Miller. My humble submission that another decision, Your Lordship, may kindly come to paragraph 40, Miller. May I please, Miller?
Just 1 minute, sir.
Paragraph 40.
Yes.
It is a settled legal position that not only an administrative but also an judicial order must be supported by reasons recorded in it. Thus, while deciding an issue, the court is bound to give reasons for its conclusion. It is the duty and obligation on the part of the court
Just
to
you
record
have-
reasons
You
while
have dictated one judgment.
Same principle
Uh-huh.
continues
These
for
are
time
two
immemorial.
fundamental principles. There is no difficulty, which I have also dictated in one
Yes,
of the judgments.
that I have copied.
blood.
This bench has at least, we remember two judgments delivered very recently on
By
this
now,
proposition.
4 to 5 judgments.
Now by this time, 4 to 5 judges.
Yes.
Who says the reasons has to be provided? Now there is a distinction whether the reason is a proper reason or the reason is a defective one
Yes.
is again a subjective matter.
Yes.
These are the judgments which talks about lack of reasons means there is no reason provided.
Yes.
If there is one line, that itself constitute a reason.
Reason, Your Lordship, if Your Lordship will come to para 160, that reason has been assigned. Your Lordship.
Wrong reason, that is one thing. And bereft of reason is another.
Number,
It is bereft of reason, there is no reason. is one thing, you are correct. But if some reason, maybe reason is wrong, maybe
No.
infirm, but that does not mean that
I am
the
not
order
saying
is,
that it a wrong region, madam. I'm not saying it is a wrong region.
yes.
I'm saying it is bereft of region because
This is not a bereft of reason. I have seen that the single bench has said that these are the points which has come, and therefore some line the single bench has said.
if your lordship will permit, then that region may place.
Please, I have said that the 3 paragraphs is dedicated for that.
In that. But if your lordship will see, that is only reiteration of the.
Sir, whatever, if the court has arrived, what the court will say? In an adversarial system, both parties have their own version.
Right.
It is a court which has to decide which version is correct. Is it?
Right.
In adversarial system.
Then, my lord,
Then one has to be accepted
Yeah.
and one should be discarded.
yeah.
If the acceptance is done, then you will say why you accepted him, why you did not accept. Then it's then the entire system should collapse.
That I cannot say.
So-
My humble submission, when I have argued the matter, when I have placed the matter, then I have shown some the region point of law. I have also advanced before the Honorable Single Judge. Thereafter, after the conclusion of the hearing, in writing, I have filed the written note of submission, giving the points and so also the decisions, rules also. Rules also I have supplied.
Please show us that these are the rules which have been violated, not taken care of by the disciplinary authority. You have raised an issue. The issue has to be decided. We are still in dark.
Milord,
The manner you have started an argument has a very, very larger negative impact.
Your Lordship, may kindly.
Please tell us that what is the rule, what the disciplinary authority should do,
Milord.
what he has not done. We are conscious. If they have not followed the statutory provision, obviously we are with you,
Okay.
at one with you.
Okay.
No problem.
Obliged.
Show us that where is the infraction.
Your Lordship,
Show us.
146, page
Please.
146.
What is that?
That written note of submission that I have submitted,
Yes.
not the specific points I have raised with the rules. Milord. Your Lordship, for a moment, kindly sit. For a moment, kindly sit.
Yes.
146. Milord.
Yes.
Petitioner begs to challenge the aforesaid orders on following grounds. Your Lordship, my first paragraph,
Yes.
I have advanced that draft on the basis of draft charges. Milord, your Lordship, my kindly sit. I am not placing entire. That on the basis of draft charges, they have initiated the proceeding and concluded the proceeding. That is my first ground.
Sir,
Second
sir,
ground,
no,
Milord.
sir, not a ground. Please read.
No.
When you say, then you should read.
Yes, obliged.
Please.
DA proceeding was commenced and concluded basing on draft charges prepared and signed by the subordinate authority, and the said charge has not been finalized nor approved by the appropriate disciplinary authority except forwarding the same.
Now, what does it mean? If we forwarded, the competent authority forwarded the articles of charges, does it require a separate order preceding that I have approved it? That itself implies that he has approved when he has issued and circulated it. What more?
That the charges have been signed by the subordinate authority.
Competent, na, except forwarding the same in his name and signature. What you
Yes.
say means
Right?
who is the authority who can?
That the senior DSC, senior divisional security commissioner,
Yes.
has to issue the same and
Show us the law. Show us the relevant the provision of the rules.
Milord.
Show us. That's your supplanto fundamento when you are taking that particular maxim. So you should know what is this maxim, what this maxim mean. And this is also the reverse. There is a reverse maxim. Are you aware? It has both.
Your Lordship, may kindly turn to page 99.
Please.
Then let me to complete that thereafter.
One by one.
Yes.
When you say that this draft charges is prepared and signed by one subordinate authority and issued by a subordinate authority, who is not an authority under the rules, show us. Matter ends there, so don't worry. It's a good ground. Show us the article of charges which is served by you which is served upon you through whom? Who has signed that?
Page 99, my lord.
Please, 99. That's the rejoinder.
Yes, my lord. Page 99, Annex 11.
Correct.
Page
This is under Article 9 as Section 9(1) of the RPI.
RPF Act.
Yes,
Your
rules.
lordship, may kindly turn to next page, page 100. Signature is there. They have.
It is signed by what is the designation, sir? I can't read it.
Erected and it's been written senior divisional security commissioner.
Where I do not find.
Last, my lord, if your lordship, you will see the signature, my lord. This last of that page 100. Your lordship,
Yes, Senior Security Commissioner, RPF.
yes, my lord.
No difficulty. Yes,
See, may kindly see 101.
101 is.
Yes, your lordship, may kindly see top draft article.
Oh,
of
that is one thing. You tell me that these are the Assistant Security Commissioner,
Yes, my lord.
and this article of charges is issued by the Senior Security Commissioner.
Commissioner.
Show us that the Senior Security Commissioner is not competent to issue that article of charges or show cause.
Senior security commissioner is competent, but this article of charges, your lordship, may kindly see page 101, my lord.
Sir, have you seen that this gentleman has clearly and very explicitly indicated that what are the articles of charges, what are the allegations against you? Charge 1, article of charge 2, everything is given to you.
The article of charges, my lord.
Enclosed.
It is memo.
That is separately he has not.
It's memorandum,
He
my
has
lord.
gone as
Charges are page 101.
That is the memorandum of charges and article of charges. These are the memorandum and what is the enclosure?
Yes, enclosure, your lord.
Entire case docket in 137 seats means everything is provided to you, which includes that these draft articles were prepared, ratified by me. I am issuing upon you. What more?
No, my lord, it is.
Sir,
Article of charge has to be.
In a disciplinary proceedings, whenever the authorities are there, the subordinates, after collating all the documents, propose the draft, and the draft is ratified and approved, and then it goes.
Yes, but here they have.
And he has issued, and it is not that page 100 does not contain, or page 99.
Yes.
It contains the articles of charges. That what are the allegations against you? No.
Perhaps I am incorrect, my lord. I may be.
Please come to page 99, the charge sheet.
Yes, my lord.
Correct?
Yes, my lord.
Memorandum is given.
Yes, my lord.
This is an allegation. What is the allegation against you? These are the allegations which is given. Then see the charge 2 at page 100, which says that during the aforesaid period and while functioning in the aforesaid office, such and such, is statement of allegations on the basis of which the charge are framed against such and such, allegation regarding charge 1, allegation regarding charge 2, list of the documents, list of the witnesses, everything is enclosed.
That is
137 memorandum. So article of charges is also a part of it, means it is impliedly approved and ratified by a competent authority.
Blood.
You are placing a very dangerous proposition of law.
Blood. My humble submission
Also.
that
One of the judgments, I think.
So next point.
For worshipful permit, may I pray this matter may come 2 days after my lord, so that one circular, railway circular is there.
Now
Which
I will
clearly
amend,
says that
I-
all the
I will amend my habit because I will not be too reactive now. The moment I am reactive, it gives impetus to adjournment.
no, my lord,
The moment certain difficult questions are put, adjournment.
no, my lord, your lords, that
So it's better to keep mum. Is better.
no, brother, I'm sorry, my lord. Then my lord, let me to a place, my lord.
He has
That
she in the entire writ appeal. We have not taken this.
Stay application.
One of the brief. Computer page 25.
So can you justify your ground J? Can you show me a law? Internal page 17 of your writ petition.
that I have
G-
indicated there, my lord,
J and I. Where is the law?
that.
Where is the law, sir?
Pappara, I have indicated for the recent decision of the Supreme Court that
It talks about the reasons to be given. Where is the law that says that 2.5 months is too late?
But there are observations there.
I know the judgment just reverse. reverse, where the Supreme Court has said that the 3 months period is to be provided. And if it is delivered within 3 months, no difficulty. And this was delivered within 3 months. So how can you tell us, show when you are, may I use the very harsh word, castigating the honored judge, then you should show the law. It's very easy to bash. Support the law. Given a judgment of Anil Rai of the Supreme Court, Anil Rai, give it to him. Anil Rai, I think 2001 judgment. No, that is for the reasons to be given. That's we understand. The reason is sine qua non that we have also had.
Yes.
There is no difficulty. But what about he's saying that took 2.5 months, so bad.
Yes,
Show us one judgment. I'm giving you a judgment of 3 months, where the Supreme Court delivered within 3 months. If it is delivered within 3 months, fine. No difficulty.
yes. Well, also kindly give me some.
Please, Anil Rai's judgment.
2001. Yeah, 2001. Supreme Court.
Anil R.A. Rai.
2000 kate page. 2100 something.
Even a subsequent judgment has also diluted the judgment. There's a case of a HON'BLE. Yes, 2001.
Yes.
Probably, if my memory goes right. What it says, within 3 months. What is reporting?
Reporting is 2001 supplementary 1 SCR 298. 2001 INSC 342. AIR 2001 2184 something like that.
Why you have taken this ground? Which is contrary to law and have some personal remark.
That is not possible. It is not my intention to make any personal remark.
That is what your
I have
intention
taken one
was.
ground
That loss of memory, kindly visualize, that's a loss of memory. Incapacity to recapitulate. Incapacity to remember. My brother still remembers the case when he argued there 7 years before. You are desperate about it because you have suffered a punishment. We appreciate the mindset, the agony, the anguish of the delinquent or the officer or the staff or the employee. But that does not mean that it will go to a great of extent like this. But appreciate it. And you are also an officer of the court. Your first and foremost responsibility is to uphold the majesty and the sanctity of the institution, not to undermine. If you draft it, then it should be. That's your first duty. You are the person who really maintains the dignity. It says paragraph 10, where the judgment is not pronounced within 3 months from the date of reserving it, any of the parties in the case is permitted to file an application in the High Court with a prayer for early judgment. Such application as and when filed shall be listed before the bench concerned within 2 days, excluding the intervening holidays. And then say, if the judgment for any reason is not pronounced within the period of 6 months, any of the parties of the said list shall be entitled to move an application before the Chief Justice of the High Court with a prayer to withdraw the said case and make it over to any other bench for fresh argument. It is open to the Chief Justice to grant the said prayer or to pass any order as it deemed fit in the circumstances. This is what? That means 3 months' time is given to deliver a judgment. Thereafter, the mentioning can be done. If it is not done within 6 months, that you can apply to the Chief Justice for assignment to another bench for fresh argument. But it does not mean that you will make a caustic remark on the judgment. Not desirable, at least, is a very healthy way of preserving the majesty of the institution. Everybody is a part of it. Nobody, even you, are a very integral part of this. What a read paragraph 9 of the observation of the Supreme Court, Justice Sethi's. It is true that for the High Courts, no period for pronouncement of the judgment is contemplated either under the Code of Civil Procedure or the Criminal Procedure Code. But as the pronouncement of the judgment is a part of the justice dispensation system, it has to be without delay. In a country like ours, where the people consider the judges only second to God, efforts be made to strengthen that belief of a common man. The delay in disposal of the cases facilitates the peoples to raise an eyebrows, sometimes genuinely, which, if not checked, may shake the confidence of a people in the judicial system. A time has come when the judiciary itself has to assert for preserving its stature, respect, and regards for attainment of the rule of law. For the fault of a few, the glorious and the glittering name of the judiciary cannot be permitted to be made ugly. It is a policy and purpose of law to have a speedy justice, for which the efforts are required to be made to come up to the expectation of the society of ensuring speedy, untainted, and unpolluted justice. Under the prevalent circumstances in some of the high courts, I feel it appropriate to provide some guidelines regarding the pronouncement of the judgment, which I am sure shall be followed by all concerned, being the mandate of this court. Such guidelines are, which I read, where the judgment is not pronounced within 3 months from the date of reserving it, any of the parties in the case. This is what is the mandate which is given. So you can't say that if it is delivered within three months, that why he did not.
Blood, I have not questioned this.
Sir,
I have not questioned.
What is this?
Blood,
May I read for you? For that, though the matter was heard on 2/5/2024, but the judgment was pronounced on 31/7/2024 after 2.5 months.
yes.
In this context, it is humbly submitted that the judicial discipline requires promptness in delivery of judgments, as aspect repeatedly emphasized by the Honorable Court. This deprives any aggrieved person of the opportunity to seek further judicial redressal in the tier. For a recent judgment, then you are saying judicial discipline requires promptness in the delivery of judgment, as aspect repeatedly emphasized by this court. The problem is compounded where the result is known, but not the reasons. This deprives the aggrieved person of opportunity to further. What is this? When you say you are talking about many things. Anyhow, You should introspect. We can't say anything on that. You are one of the officers of the court. Yes. Any other grounds you want to agitate apart from this draft?
Then, my lord, your lordship, kindly turn to my lord. Once again, your lordship, kindly turn to page 147.
140. Yes, sir.
I raised the point, bullet part 2, my lord. I raised the point of this is a case of no evidence. The
Correct.
complainant Sri N. Srinivas, on the basis of which the criminal case was instituted and simultaneous proceeding, disciplinary proceeding was conducted. Sri N. Srinivas, in his examination, has specifically admitted that he has never complained against the present petitioner. Rather, he had lodged the complaint against other three staff, namely such and such, such and such. It was he has never complained against me. But the next point, my lord, the findings arrived at by the disciplinary authority is perverse. While recording his dissent note, he has indicated that the evidence recorded during preliminary inquiry cannot be washed off. The entire findings of the DA are basing on the preliminary inquiry report and evidence collected that point of time behind back of the petition.
Yes. This is a important point. Yes, we have to admit it. The preliminary investigation or inquiry is done in contemplation of an initiation of a disciplinary proceedings, and ultimately before the inquiry officers, all the evidence has to come. If there was any evidence which was gathered at the time of preliminary inquiry, then evidence must come before the inquiry officer. If it is not, then only on the basis of the inquiry, preliminary inquiry. No. Has it been proved? He says that it was not proved. Then the disciplinary authority ought to have said that the inquiry officer's finding is not acceptable. These are the evidences which are already adduced before him by the witnesses. These are the materials which are already taken on record. And then it does not really justify this conclusion. That is the role of the disciplinary authority. Yes. Sorry, this is admit issue notice. No, this point is to some extent I find, but not the other point. Yes.
Item number 3.
May I please also? These two.
Yes.
These two petitioners are officials of this honorable court, madam, attached to the former senior judge of this honorable court. And the allegation was fabrication of record. And there are
Allegation is
fabrication of a suo motu proceeding record.
fabrication.
Other allegation regarding registration of a case. And two officials, the Registrar General as well as the Deputy Registrar, were also proceeded against. This is proceeding number 1, and the second case was proceeding number 3. The Registrar General is proceeding number 3, and the Deputy Registrar is proceeding number 4. So far as the other cases concerned, regarding other officers, the Registrar General and so and so recently, delivered a judgment. This honorable court delivered judgment, and I'll place that. But so far as these allegations are concerned, I have taken various grounds. That's why, my lord, when this honorable court had this matter on 28/1/2025,
Is it come to, will it come to me or there is?
Better because he has dealt with that case.
No, it is arising out of a same.
Same. It is arising out of same
same proceeding,
Same context.
same incident.
So,
Registrar General and the other officers, my lord, were downgraded with scale. And here, my lord, compulsory return.
No, I was just thinking about when the other bench has taken up the matter, whether this court has the assignment
So that
to deal with this cases.
28/1/2025.
Or
So
it
then
is,
taken up by the Honorable Acting Chief Justice.
no, maybe
Madam.
Mr. Tripathi, but my lord, wishes to know that if a particular bench has dealt
My lord, Justice Sinha is not here. That's my lord.
is different.
No, the other two cases, my lord, were taken up by Honorable Justice Sahu.
That is what we are thinking of.
And-
Whether
Well-
that bench has the assignment, we call it there as a determination.
I thought, my lord,
Or the roster, whether the roster is given to
Well-
that bench or this bench. Huh?
Yes.
Service of the judicial officers and employee of the High Court, that will go to Justice.
My lord.
That's a go to bench 3. Look at it, it will not come here. That is what I was just surprised. Look at it, give it to him.
Your Lordship is correct. As per the, I know that. As per
Oh,
the
then
roster-
go there. Why here?
No, because, my lord, if you also look at 28/1/2025.
No, at that point of time,
Yes.
Justice Sinha,
Yes, ma'am.
he had a original determination, he might have taken it. But now the new roster has come.
Well,
So if it is before assigned to a particular bench, then it has to be moved before the bench.
well,
Give. The instant matter pertains to the disciplinary proceedings initiated against the employees of the High Court. Stop. The category of such matter is assigned to a bench presided over by Justice, is assigned to a bench comprising of Justice K.R. Mahapatra and Justice A.C. Behra. This court does therefore releases the matter. Now, let this matter be delisted and be listed before the assigned bench.
Item number 4.
Both the matters will go there.
well.
No, second matter is judicial officer or non-judicial officer?
No, this is personal assistant of my lord justice.
Item number 4.
Challenge the judgment manner.
Item 5, sorry.
Good.
Item 5 also the same judgment I am assessing.
Yes.
Item 5 also same judgment.
Which
Common judgment.
That is the common judgment manner.
Common judgment, my learned friend has filed 3 cases, I have filed 1 case. That is that item.
I'm assessing the judgment manner. That is at Annex 1 manner. On the ground that the petition, the single judge has not appreciated the correct facts manner. Case is manner. Being selected a regular process of selection. Petitioner was appointed as a driver on contractual basis. Okay.
Yes.
Oh, government. Party, which was who. Here in this case, his name is there.
His standing counsel.
Transport department. Commission.
Transport.
He appears for transport
Commission.
department.
So his name is not reflected in the cause.
Possibly along with Mr. Samrishman, that's proper way, along with.
What does it?
No, no, this
Cause was
shows state of Odisha. Normally they are.
of lawyers.
One,
One line.
Prabhakar Behra.
Prabhakar
It's for
It is not
commissioner.
reflected, so he
Commissioner
must
of
have,
Transport
he must have missed in the list. You have served copy on him.
Government
I will
has
serve copy on him.
Government. Because finance department also
So-
party.
Serve copy on Mr. Prabhakar Behra, then
Yes.
it
The
can
final
be
director will
He's-
serve.
He is, my lord, reluctant to receive until unless he is being asked. My lord. I have also.
Will give
No,
you-
he argued with
No,
the-
they have no panel count.
He's the officer of the transport commissioner, my lord. He is not for the government.
Not for the government.
But he's a, the transport.
Then who is the party here?
State of.
For finance department
Finance
and
department.
Principal Secretary and Transport Commissioner is a party here.
Yes, yes.
Respondent number 3.
Yes.
So he's
the transport
representing that
commissioner, transport commissioner and regional transport officer,
officer.
he appears.
He.
And 1 and 2,
Government.
you appear.
For department also in some cases he is appearing. Mr. Behra.
Do one thing.
So the supplements.
Huh.
Direct him to serve the copy.
We'll serve
What
it.
is his name? Look at the-
We'll serve it.
My lord,
Yes,
as far as the RTC is
Since,
concerned.
since opposite party number, since transport commissioner and regional transport officer has arrayed as party, opposite parties 3 and 4. Mr. Prasant Kumar Misra, learned advocate, is instructed to serve copy of writ petition on Mr. Prabhakar Behra, learned standing counsel for the opposite party number 3 and 4. Hello, the registry may reflect the name of
Tomorrow I will
Sri within two days. Within 2 working days could be registry may reflect the name of Mr. Prabhakar Behra, standing counsel for 3 and 4 in the cause list on the next date of Mr. Das, Bibisar Das Leonard, additional government advocate, appears for opposite part number 1 and 2. Right. Adequate numbers of copies of writ appeal be served on Mr. Same thing in item number 5 also. Tag kar do.
Involve a urgent dream order. They will be out of employment. Can
No,
it-
actually,
Next week,
next week also.
Option to judge.
No, next week in his presence only.
Yes. I will serve the copy in course of the day.
Next week also.
Monday.
This 2 letters after the judgment, my lord.
Course of the day अपन दे
Yes,
दो.
in course of the day I will supply. Because there is
अपन दे दो in course of the day
Yes.
we will fix it on Monday.
already.
My lord, I will tomorrow. I will tomorrow.
हाँ Monday हाँ होला ठीक है by tomorrow पर्यंत
ନା କପି ଆଜି ଦବୁ କାଲି ଟେକ୍ ଅପ୍ କରିବା ପାଇଁ କହୁଛି।
Monday ଆସିବ ଆପଣ କହିଲେ Monday.
ତ ମୁଁ ମନେ
He needs 2 days time. He needs 2 days time
Yes,
to take
yes.
an instruction from this transport commissioner. How can you say that today evening I give and that tomorrow in the first day?
Exactly, my lord.
Is
There
a-
is a threat of termination. Only
Oh,
that.
whatever. That is-
You sought for regularization of employees.
That was rejected.
That
Now
was
letter has been
rejected.
issued.
Yes.
Letter has been issued to terminate us.
Whatever, they will take care. Come on Monday.
By
Where are they working? Under RTO.
RTO.
Accused and
As drivers.
Government, yes.
As drivers.
Yes.
Yes, tell the
Item number 6.
Monday की.
Well.
Monday की. Tomorrow. Sir, by tomorrow.
Right.
Monday.
Item 6.
You just take the losses to the page chart that I have in B. But there is B.
you are an employee in the Cuttack Municipal Corporation. Serious allegation.
No, serious, it was
Serious allegation.
termination. One allegation was dropped, in another it was a stoppage of single increment with cumulative.
No. What is charge 1?
Take the losses, like from the, because the writ petition contains the.
Oh,
Your
this,
lordship,
this imposition was done long back and thereafter it is given effect
given
now.
effect. In the meantime, he got 2 promotions, otherwise also. And if your lordship should just have a look at the date chart,
Yes.
they say that I was in an administrative position where I could have myself ensure that the order is implemented on myself.
True, when you are the authority to
No.
deal with it, you kept or hide it for a pretty long time.
Yes, that is what their allegation, but which
Did
is
not
not.
let it go to anybody.
So, my lord, I'll just show to that extent what has been.
How long you were there in that position?
I was there, my lord, till 16/7/2009 when the penalty was imposed.
Thereafter?
Thereafter, Lord, 29/7, 3 months thereafter, I was transferred to the as an in administrative capacity to SB Medical College. Prior to that, I was never in administrative capacity where I could have done it. Because the termination, the punishment order, if your lordship could just have a glance. That is page 10 of the writ petition. Just for a moment, if your lordship should have a glance at it.
Oh, I have to go back.
My lord, so
Where is the repetition? Yes. Which one? Page?
Page 10.
Yes.
Lord, whereas disciplinary proceeding was initiated against Srimati Sanjita Das, ex-additional executive officer, Cuttack Municipal Corporation, that is in 2011 when the order was passed. So and so, under rule so and so, the disciplinary proceeding dated 16/4/2002. First is after 7 years, after 9 years, they itself they concluded the inquiry and issued the punishment order.
You did not challenge it. You
No,
ought to have challenged it. How can
I'm
you?
just pointing out.
Yes, how
I'm
can
not
you reach
challenging
this point now?
And whereas the delinquent
No,
officer.
where is the decision that they have taken that it was kept hidden?
No, that is in their pleadings. That is only in their pleadings, which was rejected by the Honorable Single Judge.
What is the finding of the single bench?
The lordship should come to.
That's from page 28.
30 para 11. 30 para 11. 30 para 11. Page 30 para 11.
No, that is so, my lord. Prior to that, if your lordships would come to page 25. What is their stand?
Actually the onus was
They have
shifted upon you.
shifted to me.
Upon you to say that once you know that this punishment is inflicted, you ought to have
I have also.
you ought to have embraced it
No, I have
and communicate to the authorities that please impose those penalties on me.
me.
And since you kept silent,
So can that be, my lord, a reason?
can you show me a judgment? Because there are two possible thoughts from a common principle
Perspective.
on a common principles that would come.
So if you
The
just
one line of thoughts must be that the punishment is inflicted.
and I am
The
and I
punishment
am aware of it.
still stares at the face. It has not been interfered by an authority. Then in that event, such punishment, even if it was not implemented for a long time, why not it should be implemented.
Their own
The second line of thoughts is
yes.
that if there was a silence on their part and they did not activate it, and in the meantime, certain rights have already been created by giving a promotion.
Influx of time and
Now,
giving promotion.
at such a belated stage, this implementation shall affect whatever the promotion that has already been given to you. So whether the right which has now been vested, can it be taken away by virtue of the implementation?
All right.
So these are the two line of thoughts.
Both sides.
Both sides have to be considered.
Absolutely. Tomorrow your lordship may keep it. If at all I come across any judgment on any side, my lord,
Yes.
I'll
please.
bring it before you.
In para 10, Honorable Single Judge doubts somewhat your
I know, but
conduct.
no, my lord.
Your
The problem is the
not
date lines.
very particularly conduct, but your approach.
No, my lord, the date lines have not been properly read because when I was imposed the penalty, I was not in that position. After later on I
After
joined,
being transferred,
I immediately wrote to the superintendent.
She was not
there
there.
is no evidence. That
I
is-
have given.
No, there is no seal, official seal.
No, official communication from me to the superintendent. That is on record.
That is doubted in para 10.
No, my lord.
Perhaps doubted.
Please come. Please come. With those line of judgments, please show us.
I'll.
This is something very unusual. One has to think. Both ways are possible.
Tomorrow, your lordships.
Yes.
Subject to your lordship's convenience.
No, it's tomorrow come.
Item number 7.
May I bring? Here I am questioning Annexure 12. The order of the Honorable Single Judge. Where Annexure 8 was implemented. Annexure 8, that is 36. That was implemented for the Honorable Single Judge. And the facts of the present case alerts, here the present applicant is on management of a
You are challenging an order of 3rd of April 2025.
Annexure 12. Yes,
3rd April.
hard prisoners. That is page 141. And now the management will assist. He the management and run the special school, not the branch school. And the order of the collector was passed discharging the prisoner from the management. The invoking clause 11.7 of the guidelines. And again that was entrusted to the Rector Society. And I question this before lordships. Your lordship pass it. But kindly see, the most important thing is the order passed by
No, it appears that there is no final conclusion has been drawn as yet.
Yes, sir, that
Where is
done.
the writ
Annexure
petition?
8, your lordship, Annexure 8. Annexure 8,
It
that was,
says that the date for hearing is fixed. Fresh inquiry report. Preparation, the matter has already been fixed on 16/4, so there is no point of.
I think it was passed. Then they approach the lordship. Then they say that the inquiry is conducted. This is the matter. Lordship directed. Lordship kindly see the order.
Give me that writ petition. This one.
The petition I will annex to it. That is matter.
Yes.
Lordship kindly just advance let's page 32. Page 32. The lordship the order of the honorable
Where is annexure 8 there too,
Annexure 8.
which you have challenged in the writ petition?
Yes, Annexure 8 minutes. That is page 36.
What this letter says that
The letter says, my lord,
and you have not handed over any material issuance of balance fund to district such and such.
Your Lordship, kindly see page 34. Your Lordship's order. Then I'll go to that. Kindly see page 34. The relevant portion is page 34. Starts from 32, Annexure 7.
No, you are talking about the order of 13/8/2024.
38 to 24. What is the order, Your Lordship? See?
Yes.
Para 9.
Just 1 minute. Yes, so you were permitted to run the management of the school.
Yes.
That's all.
That's
And
all.
the fresh inquiry was directed to be prepared.
Yes, Lord.
So what is the difficulty?
So
Then
that order, Annexure 8 was passed. But my submission, that is not in compliance. They have not handed over the institution as yet. And now they say that no, we have not taken over the institution. Lordship, kindly see the Annexure 8. They have taken over the institution. I approached the Lordship passed it and directed to return to me. And without giving me the institution, now they said no, we have not taken over. The students are with you.
no. What this letter says, this is 8/11/2024 letter.
Yes, Lord.
It does not talk about anything.
I am from please, Lord.
Please read it.
Yes, Lord.
Where it says that you can't.
Yes, Lord.
I think my understanding of language is very bad.
No, I can
Please
say.
tell me.
Just I am pressing Lord. What?
Please.
With reference to the
Correct? Whatever.
cited subject,
Correct?
in connection with the past by Honorable High Court Sessions,
Correct.
I am to say that your NGO of Unnasam is continuing both the special.
So you are permitted to run. Is continuing is in presentee. So you are continuing to run. Then what they have said is continuing.
Without GIA. Got it.
Correct. Whatever. But you are continuing. Maybe without any government order. But you are continuing.
Grantinate. That is GIA means grantinate.
Granted. Whatever.
That is grantinate.
Maybe you are continuing.
And you have not handed over the material students or balance funds.
Correct.
So that means students are lies with me.
Oh, whatever it is with you, sir. Read.
And honorables, you may apply for GIA to both the school to SSC department for considerations.
That's so.
So
You may comply, you may not comply. It is not mandatory. Only thing is the court says that you should run the management till the final the fresh inquiry report comes or decision is taken. Which they have recorded. Yes, you are continuing without any grant in it.
why they am saying so? You're answer fine.
So how it affects your right? Your affectation of right is means if you are you are not allowed to continue by them, then you can say that they are acting contrary to the order of the court.
What I pray, Lordship, just
Can they not ask you that why you are not providing me this part?
What order was quashed? Lordship, kindly see page 28. Just across page 28. Lordship, I pray, Lordship, see page 28. Only I pray, Lordship, I will convince Lordship.
No. No, definitely not. Definitely
No.
not.
But I pray, Lordship, kindly just across page 28. This will answer my Lordship's query. Page 28, Lordship, see.
Yes.
Annexure 5.
Annexure 5, what it says, and
Yes,
let him satisfy his conscience. Yes, what annexure 5?
That was the impugned before the honorable single judge.
Yes, this is what is impugned.
No, that's the second. First round. First round, the order was passed. The annexure 5 was passed.
First,
No, what
because
is the order 5? Kindly see what annexure 5 is.
read what I order 5.
I pray, see.
Please read.
Page 20.
Please read.
Right. In pursuance to letter of such and such or director such and such, the collector and district magistrate HON'BLE has been pleased to make an interim arrangement for smooth management of the following two number of schools. Such and such, in view of the present situation until further order, the following, the overall management is entrusted with the secretary, district director society.
Correct. That means, the entire management and administration of those were taken away from your hand and was entrusted or given to somebody else.
Yes.
You challenged it.
Yes.
The High Court, this court set aside that order.
Set aside.
Says no, you can't take up the management without initiating a proceeding or making an extensive inquiry, and then say that you are permitted to run.
No, management now with them. The entire force, the staff, entire thing that is there. The granting entire thing is there.
Sir, this letter, when you are challenging in this writ petition, this letter is addressed to whom? Is a secretary of the NGO of this?
Myself.
Yourself?
Yes.
He says that you are continuing without granting it.
I said that in view of annexure 5, I say annexure 5. They have taken over entire thing. Now nothing with me. Now they said that then what is their adjudication? What is there for the inquiry? Now the inquiry is, Lordship said that kindly see annexure 5. Annexure 5, the entire thing that was taken over. The management was taken over. The money was taken over. The staff were taken over. Now all the staffs are there. The money that the granting is there, my lord. Now I am without nothing. Now they say it is compliant. Kindly also annexure 5. If that is compliant, what I am saying, then what is the annexure 5? What lordship was? And only one thing, lordship kindly see, what is the law? What I am saying. Last 4 years now the management with them. Still that are not been taken over, that are not been handed over. That was the cryptic order passed saying that no, you are continuing. If that is continuing, then why approach the lordships? I approach lordship challenging annexure 5. The annexure 5 says the overall management is entrusted to the secretary directors. And the day-to-day affairs of school managed by the district social security officer. Day-to-day management. The account of the school will be jointly operated by the secretary, district director society, HON'BLE and district social security officer. Now the entire thing, this is a headed institution. Now the money now that lie with them, they said that you apply for granting it. We have not taken over the institution. Then the entire the money is sanctioned by the government. Now they are enjoying. The staff, you know the staff of mine, that is 27 staff. Now they are with the Red Cross. Now I am along with my buildings and the old students. And you kindly see what is the law. The law is, kindly see the opinion of that person who deserves that. Just a glance on what is the law. This is a central act. I am relying on section 50. Yes, sir. Any institution that is mandatory may permit to test minutes. I may permitted to placement, only one. Save as Central Act. Save as otherwise provided, section 50. That is, I think, 24.
Yes.
That is registration of institution for persons with disability and
Which
grant
one?
to such
A rule or a act?
That is Act.
You are
Section 50
reading section
50, 50.
5. Yes, sir.
Registration. Registration of the institution for persons with disability, that is there. Save as otherwise provided under this Act. No person shall establish or maintain any institution for persons with disability except in accordance with the certificate registration issued in this behalf by the competent authority. And the competent authority, page 49 is there. That is also there, page 49 is there. Now my institution received the permission, recognition, affiliation from the competent authority. And Millers, the granting principle that is issued by the government, let's say kindly just of the last, that is the relevant rules. Let's say kindly see page 184. 184, that is the rule governing the field issued by the state governments. Kindly see page 184. That is the, let's see, what it is.
No, I'm not going there. I'm not going there. Yes. Yes.
Not page 184.
Yes.
Let's got it that.
Yes.
That for establishment, recognition, and granting it to the institutions imparting education to the children with disabilities.
Yes.
Next page, Millers. Definition. The Act. Definition section 3, clause B. Act means Persons with Disability Act. Let's got it. That is there. And so far the permission, recognition, that is there. Now, Millers, kindly see clause 4. Establishment of new institutions. Institutions willing and capable of imparting education to children with disabilities shall submit an application to the collectors. Then
Yes.
eligibility criteria. The eligibility criteria, clause 5, should have registered under the Social Registration Act, should have registered under the Person with Disability Act, should have registered under the Juvenile Justice Act. These are the criteria. Then let's clause 7, permission, how the permission should be granted. That is there. And the content of the permission, the institution in whose favor is granted, location of the institution, everything that is clear, Millers. Then the most relevant procedure is, Millers, that is clause 10. That is the granting act. Clause 10, A Roman 1 says that the institution must have completed 3 years from the date of recognition for eligible to receive grant. 3 years is mandatory. After completion of 3 years after getting registration, then you can apply for granting it. And accordingly, the granting was released in my favor. Then, clause 3. The number of teaching and non-teaching staff for institution will be as per the yardstick prescribed by the government. How many staffs will be approved? That is also yardstick is there. Now, my students is 87. So, accordingly, 27 staffs are approved. Then, most important is clause 7. In case of any dispute in the management of the aided institution, or if the government receive any serious complaint in the running of the institution, the collector of the district shall be the authority to suspend the management and make appropriate alternative arrangement for running of the institution so as to prevent disturbances in education of the children with disabilities. So this is the special role of the collector. Whenever there is a chance of disruptions of the study of the students, then the collector can invoke that powers. But by invoking this, the Annex of 5 was issued. Annex of 5 that was issued in the year 2021. That the management vested with the DSSO and directors, that is Annex of 5. Page 28. That the collector passed the order on 22/7/21. The overall management entrusted to the secretary, district across. Day-to-day affairs of school shall be managed by the district social security officer. The account of school will be jointly operated. Thereafter, Millers, what they have done, they have formed a new management. That is also the part of records. That is the next Annex of 6. 6/3/2023. They stated that the sub-collector will be the chairman and the secretary, all these things are there. So these both the letters I challenge your lordship. And the lordship said these two letters are bad in law. And according to this class sheet and direction to return to hand over the institution. Institution means the staff, the students, the grantee, all these things. Now the grantee is enjoyed by the collector, by the DSSO. The entire 87 students now the money was sanctioned. Now they are enjoying the money was granted. Now that the staffs are with them, they are not returned. But now they say that we have returned, you are running the schools. So I challenge this. So the Honorable Court said that yes, have you conducted inquiry? They said no, we will conduct the inquiry. And now this was posted to this April or more now. The order of past pillars, the Annex 8 was passed in the year 2024. Pursuant to Lordship's order. Well, my simple question, my Lord, whether that is compliance of Lordship's order. Where Lordship said that you first return the management, then conduct the inquiry, then pass necessary orders. Now they said that no inquiry necessary because you are running the institution. While issuing notice, they said that yes, we will conduct an inquiry. And the statute is very clear. Now the school is mine, permission with me. Now how they are running my schools without permission, without recognition, nothing. They said that I am running. They said that my students with me. Then my students with me and I am running. Then you are enjoying the 99. Then the staffs are there. If the staff, the approved staffs are there, then how can run institutions?
Yes, that's all. So can we proceed to dictate?
Yes, sir.
Yes. To dismiss. A disgruntled litigant approaches the writ court, assailing the letter dated where is this annexure 8? Assailing the letter dated 8/11/2024 issued by the Additional District Magistrate HON'BLE requiring certain materials and or documents to be handed over for the purpose of the inquiry or the consideration to be taken in this regard. Undeniably, the appellant was running the institution, and subsequently the management and the administration was taken over by the authority on the basis of certain complaints and of the allegations which were prima facie appears to have been substantiated. Stop. The appellant challenged the same before this court in WPC number 5509 of 2013. Which came to be disposed of on 13th of August 2024 with the following directions, paragraph 9 and 10 of the said order to be quoted. It is thus manifest from the observations recorded in the above order that the appellant was permitted to run the said institution for the time being, and the authorities were directed to make a fresh investigations and or inquiry. Stop. The reason being that the earlier decision of the authority was found to be in gross violation of the principle of natural justice, which is one of the fundamental facet in the judicial dispensation system in pursuit of rendering justice. And Therefore, it can be reasonably inferred that the moment the fresh inquiry was directed, it has to be undertaken following that the principles of natural justice. Subsequently, the impugned letter dated 8/11/2024 was issued which is construed by the appellant to have impacted their right, crystallized in terms of the order dated 13/8/2024, and approached the writ court to quash and set aside the same. The counsel for the appellant vehemently submits that the said letter is an outcome of nullifying the order passed by this court in an earlier round of the litigation, and in fact, in the gross violation thereof. It is arduously submitted that despite a specific direction passed by the writ court in the earlier writ petition, permitting the appellant to run the institution, they have not been permitted to do so, and therefore the impugned order, the impugned letter is an outcome of a malice and issued with a malafide intention to subvert the right accrued in terms of the order passed in the earlier writ petition. The reference is also made to the various provisions of the Right of the Persons with Disabilities Act 2016, relatable to the registration of the registration of the pertaining to the registration of the institutions for the persons with disabilities. And to buttress the submission that the authorities cannot violate such mandate and take an action contrary thereto. The sequel of events as narrated here in our evince that the said institution was managed and run by the appellant, being the non-government organization. And complaints were lodged against them not only by the employees, but from the other quarters of the section of the societies, which led the supersession of the management. And the order in this regard was passed by the competent authority. Obviously, the petitioner challenged the said order in the writ petition, which was quashed and set aside on the ground of the violation of the various provisions of law as well as the principles of natural justice, with categorical observation that for the time being the petitioner may be permitted to run such institution. Simultaneously, the order was passed to make a fresh inquiry, and the impugned letter dated 8/11/2024 issued by the ADR not only replete the direction of the court that you have been permitted to run, and in fact is continuing to run the said institution, but is indicative of other fact that such continuance in managing and running the said institution is without any the grant in aid, and therefore you are directed to hand over certain materials as indicated therein to the department. We do not find any incongruity and or ambiguity in the said letter which would tantamount to subversion of the order of this court in relation to the management and administration of the said school is concerned, as the language employed therein is explicit and clear that the petitioner is continuing to run the said institution. Stop. Whether this institution managed by the petitioner, managed and administered by the appellant, is with the grant in aid or without grant in aid, is an issue to be decided, to be taken up by the authorities, to which we are not concerned with. There is no other stipulation provided in the order passed in the earlier writ petition, except to the extent as indicated herein above. And therefore, any other requisition is made unconnected with the subject matter of dispute, subject matter of dispute involved in the earlier writ petition, it is not open to the appellant to contend that the action of the authority is in gross violation of the directions / order passed by this court on 13/8/2024. The letter neither undermine the authority of the appellant in continuing to run the said institution, nor could be perceived to have impacted any rights accrued in terms of the order passed by this court on 13/8/2024. Since the authorities are in the process of making a fresh inquiry, which is also reflected in the impugned order, we do not find that there can be fetter. We do not find any reasons to put any fetter in continuance thereof in terms of the order passed on 13/8/2024, and therefore the ultimate decision taken by the single bench cannot be faulted with. We do not find any grounds warranting interference with the impugned order. The appeal is dismissed. The connected applications are also dismissed. Sorry, can't accept. Yes. Next. Yes. Yes. Call.
Item number 8.
Yes, 8. Yes, 8. What is this?
I have filed a review in the order.
Review of whose order?
My lord, 26/11/24. And it's
20?
and it's 7 page 64. The reason is, my lord, a batch of read
No, copy of the order of the Supreme Court.
Yes, ma'am.
You are relying on.
Yes, that I have annexed also in this case, my lord. I have brought to notice on
The delay is condoned.
delay. That, my lord, I have brought to notice on matter annexure 4 page 34. Same issue, decision on appeals court in our favor.
Now, sir, now what is this? Why you have filed a review? You challenge which order?
I challenge that annexure 7 page 64.
No, before the Supreme Court.
Yes, Supreme Court given the benefits in our favor. That I brought to notice on division bench.
No. I do not. I am looking at the order
My lord,
which you have annexed here.
my lord.
It is annexure 4.
Yes, ma'am.
What is this order?
That relates to grant of retrospective promotion to junior teachers.
So
That-
review of the order dated 25/10. The review of the order dated
26/11/24. Annexure 7.
20,
26/11. November 2024. Annexure 7. page
not 28/10/2021.
No.
26.
26/11.
Where it is?
Annexure page 64.
Huh?
Annexure
Page
7.
Annexure 7.
Annexure 7.
Okay. This is passed by.
My only justice, but my lord, Justice Haman.
Oh, so my brother, you address him. You address him.
Yes, my lord.
Yes.
Yes. So, this
He has to see
Yes.
that what is a apparent error on the
This-
face of the
yes.
record.
Yes. This case relates to grant of retrospective promotion to junior teacher on the date of completion 3 years of service. As per the 272, where it is rule 10 clearly mentioned on completion 3 years of service, the LSA teacher having dual qualification is entitled for promotion to junior cadre. Several cases filed on tribunal. All allowed. Government complied the order. We approached on tribunal. Tribunal also allowed our case, but in the review also dismissed earlier. But the review on the divisional director let the government take a decision access.
Review means?
The review is filed by some person challenge for review of the violation of the order of division. In division bench, when reviewing the order, director let the government take a final decision, take into consideration that the benefit already extended to similar to persons.
So that was passed on a review application.
Yes. We
So-
accordingly, government rejected our case. We challenged before the single judge. On single judge, 44 requisition filed. By clubbing all the cases, 3 days allowed. It is like 3 decision of appeals court. The single hit was filed. We from very beginning from on the date of on the first date, we mentioned that all the requisitions should take together because different judge can consider there. But on the very same day, hearing was closed. We are not able to file counter. I filed a written note, include the judgment of on appeals court, as well this judgment of this court division bench, which confirm the which has dismissed the original application, the requisition confirming our order.
Review, will you
And-
say? For review.
Review that during pending we are not given a chance of filing counter. After that, I file a written note enclosing the judgment of appeals court during pendency of the case. Hearing
I am asking you, what is the ground for review?
That review
You should be conscious of Order 47, Rule 1.
that has been decided on appeals court. We are giving the judgment of appeals court in the same issue. that not questioned at all by the division bench. That is the decision of appeals court 96.
What?
We have held the judgment of appeals court during pendency of the case that this is the judgment of appeals court in their favor. That are not at all considered by the division bench in this in the topic. That is the decision for which in similar matter this one directed that in the this is upper face of record, so review should be considered.
Non-consideration of a judgment cited before the court is a apparent error on the face of it.
Yes, that kindly see paragraph 30. Paragraph 13 of judgment, page 5, paragraph 13. Kindly see.
Do you approve that?
No.
Paragraph 13. Article 41. Paragraph 13,
I
madam.
don't know.
Page 5. Article 141 Constitution provides that law declared by the Supreme Court shall binding all courts within the territory of India.
Secretly, when everything is considered.
Paragraph 13 of judgment, I said. Article 141 provides
I've
that law.
seen,
Huh?
I've seen 64.
Yes. That,
That's a constitution based decision.
yes, madam. That rely on that the division of the court and allow the review and director of face hearing. Kindly see. Supreme Court and filed and High Court takes
What is the judgment of a Rupa Hura? Ashok Rupa Hura of the Supreme Court, also larger bench decision.
This is the constitutional bench judgment, madam.
I know.
That they say
Tungabhadra is a classical case on the review. Is a one of the classical citation on the review. No doubt.
I have no knowledge. But these decisions said, once a judgment is unappreciated knowledge of the court, he should have taken that decision should have taken consideration. When an appeals court category direct said
Whether applicable, not applicable, must be taken into consideration. Irrelevant, not to issues, not germane, everything that the court should take into the reference must be there in the judgment.
This order which I annexed 4, that related to our case. The order appeals court allowed dismiss the SL filed by the state and allow our case for grant of
Dismissed on the ground of limitation.
no kind of with also that is my enter case with enter case. Annex of 4 page 34. Enter case that is.
Judgments.
Division bench dismiss the writ petition with the direction and annex of 3 page 32. Division bench and similar issue dismiss the writ petition state government and allowed and tribunal allowed as confirmed. There my kindly see page 5 paragraph 6. Page 33. Recording such statement of the counsel for the opposite party, no one directed who direct the authority, government authority to implement the order of tribunal with the summons. That was challenged by appeals court. That is page annex 4 page 34. And last paragraph. Even on merit, we find no reason to do that. That is what called appeals court and decisional court at the hearing matter. But nothing mentioned in the order matter. That was specifically mentioned that even on merit, we see no interference with order of tribunal. Tribunal directed that we should be giving the benefits. Some cases challenged with the High Court by the state.
You have dismissed on
That
ground
one-
of limitation.
No.
Create that all the case with that because the variety counsel are there. Very beginning was submitted that all the many rituals filed, all the case back together. For the same time, we and all the rituals still pending. All the rituals still pending. By the mind only request my lord. If we allowed and all the rituals they have together. Because several other counsels are there. Hearing matter then through and take a decision. That is only prayer. But minimum 40 to 50 rituals still pending. On the same order, challenging. 40 for rituals in one order, come out of the past.
Yes, madam, what do you say?
I am in a position to demonstrate how that matter is different from this matter, but on the ground of review petition matters, there is some final judgment numbers.
What?
2038 FPC P20 from which Sharma was my opinion. Wherein what where a principle has been reviewed by the Honorable Supreme Court, when a review petition is maintainable and when a review petition is not maintainable. Para 20.
So it says that unless it comes within the purview of Rule 1 of Order 47, there must be an error apparent on the face of the record. Discovery of new and important document despite due diligence was not within the knowledge when the judgment was delivered. And therefore it is. And the third one is for any other substantial reasons. So substantial reason has been interpreted is correlated with the other two reasons, not independent one.
Yes, Minister, and also minor mistakes of inconsequential enforcement or reputation of old or overruled argument is not enough to reopen the concluded adjudication. All these points are there with us, and these submissions which is being made by my learned friend, the same have been argued at length when the judgment was passed.
Will you, did you argue that point before the division bench?
Yes, we have filed the hearing was closed on 24/5. Matter kept pending for judgment. 11/5
No,
hearing.
no,
was closed.
you argued.
Huh?
You argued before the division bench.
Yes, yes, yeah.
Yes.
After the hearing was managed on the first
No,
day.
no, I understand. No, I
After
asked
3
you for
months-
some other reason. Anyhow,
Right.
no. I asked you for some other reason. I
Right.
do not ask you to
Right.
argue
Right.
again.
Right.
You have already argued.
Right.
Yes. So it is really a reappreciation or revisitation of the order in the guise of a review.
Yes, because same arguments have been done, my lords, and the judgment has been reserved after considering all the submissions of the applicant as well as the respondent.
What you will do?
The reputation of old and overruled arguments, my lords.
No.
It's up to you. Hearing concluded, my judgment, my brother will pass.
Right.
He is an author. He has to see what error he has committed, which is apparent on the face of the record.
Right.
Yes. Yes.
This judgment, you are relying, Kamlesh. You are placing this,
We handing over the one more judgment, 2020 recent judgment, enunciating the same lines which has been mentioned. Or the 22 judgment.
And also in a BCCI's case,
Anti-conducted also. No.
Netaji Sporting versus BCCI, that is also on the review scope.
Scope is another 44 due to still pending. That's all.
Well, whether that's a very good ground for that.
Item number 9.
Yes. Yes, what instruction? Why? What is the matter about?
Let's say, a bypass road was constructed by bypassing a particular town here at Baki, and originally sketch was prepared in a straight way road.
But they are making the
They have
cover.
created a blind court 2 to 3 places without
Take
violating the
instruction and give.
You know, it's a kind of annex of 4. Tahsildar reported there.
Let them come with the fortnight instruction. Release the matter immediately. Yes, there are.
Item 10.
Item 10.
In case allegations of embezzlement of the funds or the financial irregularities have been projected, what are you doing?
Lordship, we have instructed that the senior counsel, Mr. Srivastava, last day appeared in this complaint.
Okay. So
And that's why I have not been served with a copy of the petition.
senior counsel, then you are assisting him.
Yes, sir.
So what copy? She has been served with a copy.
Different panel, different department.
It is vigilance,
Oh.
standing counsel vigilance.
In course of the day.
Sir, let us pass that over.
The next week.
The petition because there is different.
Yes.
After vacation.
The next week, it will be very serious.
Is the embezzlement ultimately, if they are found guilty, they will be punished? Don't worry. Anyhow, nothing more than that.
The inquiry I have annexed.
Is whatever, let us see.
Also for the petitioner. We instructed to some copy of the petition on Mr. Srimanta Das, that standing, senior standing counsel, vigilance. What? In course of the day?
In course of the day.
In course of the day. This Suman, additional government advocate, appears for opposite party number 1. Mr. Srimanta Das, that standing, senior standing counsel shall take instructions and in case of necessity file affidavit. Instructions you can file on affidavit after vacation.
19th. Item 11.
11. Affidavit filed today, e-file. I'm serving a copy on my learned friend. Might not have come on my lord's board. Was this matter on Monday?
Like today, it will be put on my impact on Monday because I'm
Monday.
gone through.
Go through.
Mine.
After vacation?
No, not because the unit is closed almost 1 month. It's a production unit, a license to manufacture.
Keep it on 14th.
Right.
Keep it on 14th.
Item 12.
It is submitted by
Sir. Sir.
Mr. Mobiles Lanet by National Government. He has already filed counter affidavit in the registry.
Right.
Registry will look at one, place it on the next date of
Last
Just hold on. My brother is dictating
Sir,
an order.
I am sorry.
Just one.
Mr. Pirga person. Is served with a copy of counter affidavit in course today. Place this matter on
14th.
14th.
Item 12, sir.
12.
Yes.
So construction, not at Kaliakera, but Balipara.
Yes.
Pardon the doctor, I got it right now, that's not the it says in annexure 1, your option page 18 in the rate. Petition. He says that the collector has said that the 4th says the subcenter site shall have good road connectivity, electricity connection, solutions, etc. And the substation site shall not be close to minimum 3 kilometers of the existing subcenter, PHC or any other public health facility. So here, what the instructions he has given is that there is a name of the facility is.
So put it on affidavit, madam. This has to be put on affidavit because they have.
1.5.
So that's true. So put it on affidavit. Let them put on affidavit. So affidavit.
Ms. Suman Patnaik and National Government Advocate has stated to have received the instructions and the same shall be put in the form of an affidavit. List this matter
Reopen.
How soon the affidavit will be filed?
क्या करिए? Affidavit when can you file? By file.
Reopen 19th.
Reopen.
Construction is going on, by that time process will.
It will, if it is wrong.
All that. Then
Item number 13.
Second. Copy of affidavit may be served on Mr. Vishnu Pradhan. In advance. List is matter.
19th.
19th June. 19th June. She will serve you a copy.
Let's call the next.
Item number 13.
Madam Patnaik. Madam Patnaik. The moment you prepare the affidavit and file it in the registry, you serve a copy before holidays so that we can get ready. Like,
Yes.
13th.
wow. Also, the petitioner is a social activist. When he came to know about the illegal appointment of 6 persons on the basis of fake certificates and qualifications, he made complaint before the appropriate authority regarding this
So
matter.
let them take a
Time and again. And
Why you are not
other-
looking into, make an inquiry, if something is there, then
Take instruction. Above 6.
take instruction. There may be more.
Yes, maybe no. I'll ask the officers to call their.
Yes, take instruction. Let it appear after.
instructions by Mr. Das. After this.
Yes.
Item 14.
I challenge the letter under Annexure 12, wherein the collector was directed the commission exercise for cancellation of license and holding unlicensed was, and some irregularities there, but a show cause notice is issued by the collector. I filed reply. He has passed order on Annexure 10. On the same day, he has passed also order for cancellation.
What
That
is
order I
that?
have challenged in appeal. Under Annexure 10, which is order has been passed at page 45. But I have filed appeal against that order under Rule 251. But under Annexure 12, on the same day, he has proposed the commissioner for cancellation as it is without jurisdiction law, without authority of law. Under Section 47, only the government has the power to cancel the license. That is not judgment of this Honorable Court also.
What? You are manufacturing as a on-shop license, having on-shop license.
I was holding on license 2024-25.
But it says that you are all, you are manufacturing, oh, you are selling also. Both.
There are 4 lawsuits there that has been held that the government is the authority because the government has granted the exclusive privilege. So the cancellation power has vested with the government, not by the collector.
Yes, what do you say?
I find from this document, the issue because.
No, ultimately a decision has been taken. There is a right of appeal. He has gone to the appeal. Now, he will definitely seek some kind of a stay or whatever. That
And
is
that has not
on
been
the same
numbered and there
day,
is
on the
not-
same day, if you say the cancel it, then it's a government who has to take a decision.
Yes, no, I'll be prejudiced there.
Is take instruction and come on 13 or 14? 13th of this month.
Not let's us stay up to this.
13th, sir. You waited. It's hardly 4 days. Yes.
Item 15.
Maybe the lordship. This is that premature release of an detainee who was in incarceration since last 25 years. Last occasion, Lordship had directed the state to produce the papers, the sentence review board minutes, with his conduct certificate that has been given by the superintendent of the jail, that he's conducting himself.
There is a review, I think the review board is there.
Review board, my lord, why have you deferred Lordship is because for the last 3 consecutive years that they are rejecting the application on different grounds.
What
And
about?
all 3 grounds that have been taken are inconsistent with each other. My lord, another point is that,
You can assail that order if they reject.
no, that is why we have assailed that order. So this, your lord,
This time also they rejected.
appreciate that, without giving any, on the merit, your lordship, the court ordered that report of the superintendent should be taken into account by the board. That has been done, your lordship.
Where?
But when you are in lordship, what happened is, everyone had recommended for this premature release. The superintendent of the jail, your lordship, then the district magistrate, the DIG of prisons, even the DG of prisons, your lordship.
Yes.
But the board has rejected it on the ground that since the day of his conviction from the court, that is in the year 2004, till today he has not completed 25 years, that is what the instruction says. And before that, as an under trial, he was there for 4 years. And your lordship, he has the potential of forming under the gang and committing crime. He still has the potential. 55 years old, 26 years in custody, my lord. And he has reformed himself. Under trial, 4 years and now he is teaching.
So propensity to organize something more after he is released.
That is there that the board has held, your lordship.
Which item number?
Your lordship, that is, in addition, in addition, your lordship. Page 24 of the writ, my lord. Page 24 of the writ, the last is at 11, serial number 11. Written that life convict along with 4 others committed bank authority with murder of bank beyond by exploding bomb in front of Unico Bank. The board has an opinion that the life convict has no process prudentially to commit further crime. There is possibility that he will form a new gang and commit similar crime, and hence rejected under clause 6(1)(a) and (e) of Orissa Act 9(4)(29). Your lordship is similarly at page 30 is his previous rejection, and your lordship is to the ground that has been given. It's a simple rejection. Page 30 is at serial 4. That is in 2021. Yes.
He is referring to this.
Serial before the board. Item number 11 at page 24. It seems they have not considered these recommendations.
Board consists of
Page?
the in the gadget your lordship on the last occasion.
Page 24.
Page 24, yes, that is the rejection reasons that they have given. Board consist of the secretary, principal secretary to government home department, he's a chairman. Principal secretary to government law department, he's a member. District and session judge, Khurda, Bhubaneswar, he's a member. Director of Health Services, Orissa, and all his nominees not below the rank of joint director, he's a member. Additional DG and IG of police, as nominated by the DG and IG of police, Orissa, is a member. And additional.
So they are all
DG
members.
is a member
They
secretary.
are all members, additional DG prisons as well as additional DG and IG police there.
We have recommended. the law.
But here DG prisons has given a recommendation. And
That I have asked the topic, they are saying. that-
DIG police also.
No, madam, there are two things. When the persons who are in the helm of affairs, that superintendent of a jail, then the other police authorities who are also DG prison and all everything, who is monitoring the conduct and the behavior of the prisoner every day. And they have been closely monitoring that. If they have recommended that there is no difficulties, then there should be some very adverse and very incriminating materials that must be there before the board to form their opinion adverse to their recommendations. So there, what was the material? We do not want to be disclosed so openly. We understand, but at least in a sealed cover there should be something would come.
Lordship, I have asked the DIG prisons to formally get that in a sealed cover by tomorrow,
Yes.
the entire record.
True.
To be produced
So
before
that
the-
is what we really wanted to look at.
Yes, I told them.
So
that
they-
this is
they
a-
must have- no, what
I said, no, it is the entire official record, so they've written to the joint secretary home department.
perhaps learned Honorable CJ will agree with me that there must be have some material to
Yes.
discard this and
This is what I really wanted.
no.
So, I mean, there must be.
That also I, so the record should be produced.
So
they-
don't disclose it to them. We know these are the very I would say authentic or secret documents.
For that it will be part of prison.
Almost all are unison.
On the part of.
Almost all are unison to recommend in favor of
Yes, your lordship, for the premature release. I have asked them today itself, your lordship, they have written to the joint secretary home department to give it in a sealed cover, the entire set of records before, placed before the lordship. Because they thought that it would be only related to prison. I said, no, it was the entire record that has to be placed. So they have, they will get it by tomorrow. We have to let it come on Monday, your lordship, the records will be there.
Yes, let them come.
I'm so glad that it has come from a lordship in this way. My lord, the last occasion a lordship had asked me this question, and what is your lordship scope of interference in this? I had cited Nilofer, but my lord, I was probably not diligent enough to show your lordship that the Honorable Apex Court has actually endowed your lordships with that power to release in case they find an abnormality or anomaly with the decision of the sentence review board. Man. That is there. I was not able to point it out to lordship. I'll do it tomorrow if your lordship gives me the indulgence. I'll do it tomorrow.
So come on 13th. On 13th.
Yes.
Yes.
Obliged.
For further instructions to produce the relevant documents.
take
Yes.
it back.
I just say.
Item note 16.
No, take it back. You furnish it on that day.
This is,
No,
this
no.
is given by them.
Oh,
It was given by man.
Yes.
Obliged.
Yes. What steps have been taken? Have you been able to rescue Miss Patnaik?
Actually, on the last occasion of their information, your lordship, and that a raid was conducted and they were there for 3 days in their village, your lordship. She was nowhere to be found. In the last occasion, as per the information, they had been to the village of that accused. And a raid was conducted, even they stayed there for 3 days apart from the lot of police persons. But there was no information on her or their whereabouts, your lordship. Last paragraph, your lordship.
This call.
May I be permitted to mention, my lords? I'm conscious of the fact that lordship have fixed the matter at 2 p.m. My item is 20. They have reached then. My lords, lordship,
In 2 p.m. matter will not last much. Just we. Yes. Yes.
May please.
Yes.
So, this is not saying my lords kind intervention while challenging. Let Odisha excise amendment rule 24, wherein the state has deleted the word dance from proviso to sub rule 4.
Can we have the physical copy of that?
Madam, please. My lords, may kindly look at
Which one? Which page you are referring, sir?
27. I mean, page 27.
Yes, sir.
Yes. While deleting the word dance from the rule book, the
Deleting
state
the
has incorporated another inserted word dance. My lords, kindly look, it's from the proviso to rule sub rule 4. My lords, kindly have a look at sub rule 4 of rule 44 of Excise Act 2017. The Excise Act 2017, Rule 44 of Excise Act 2017.
Where do I get it?
Pardon me. Rule 44. Madam, kindly have a look at the Rule 44. Rule 44, proviso, below, proviso.
Yes.
Provided that women not below 21 years may be engaged in musical program or dance program or orchestra in the liquor shops licensed to sell foreign liquor or IMFL for consumption on the premises under the jurisdiction of a police commissioner with the prior written permission of the commission. Commission has been defined as Excise Commissioner of Orissa.
So they have deleted that particular dance program.
In the amendment.
In the amendment, they have deleted the word, the dance program.
Everything is there except the word dance.
Dance program.
Yes, dance program.
So they have deleted this.
Yes, that is there.
So tell me how it is ultra virus.
Yes, I'm sorry. But this amendment is clearly in direct conflict to the settled principle of law decided by Honorable Supreme Court in the case of Indian Hotel Association versus State of Maharashtra, not one, as reported in 2019 3 SCC 429, and prior to that, their lordships have also referred to their earlier decision that is reported in 2013 SCC volume 8. And my lords, may kindly have a look for a moment. And may I pass on the copies of the judgments? I have got.
Please.
Books will be inconvenient. Yes. That was also intervention.
Yes.
My lords, may kindly have a look for a moment at page 439. Page 439 of the judgment, for a moment. But in the conclusion, my lord, kind find from the top, my lord, got it? 430. In the conclusion,
What the whole judgment is not printed.
my lord, yes,
Whole-
the books are there,
No, the whole judgment is not printed.
my lord.
This whole judgment is not photocopied.
Photocopy of the reported judgment.
Yes. It ends at page 502. That is paragraph 103. And this conclusion is at 107. So we are not getting a privilege of reading paragraph 104
Because I
onwards.
have got it from the reported journal.
Now, you have not given the complete pages. All the pages of the report.
Back page.
Yes, yes.
It is up to half
Oh, I am
of
so
paragraph
sorry. I am
103.
so sorry. I am so sorry. I could not notice that matter. I am sorry. And that is the mischief of the
Because the difficulty, I tell you, that
Yes,
times
yes,
the,
yes. I have
the
to
head
already-
notes are very deceptive.
Yes. 2 pages
So-
are missing, my lords. I am so sorry. 2 pages are missing. This is up to 502.
Book books there.
Last 2 pages are missing. There are page, my lords, may kindly look at it.
More to nine.
That is
Nine.
2019, 3 SCC 429.
Yes, sir.
Kindly have a look at page 439, conclusion.
I have already read paragraph 103, 4, 5, 6.
My I'm obliged. Well, sir, thereafter kindly have a look at, well, their lordships, while making a critical analysis of the submissions made on both on behalf of both the parties, their lordships have held at 440, page 451 and 52. I am placing it for a moment. Page 451, 52.
What has been held there is that putting such kind of a restrictions
Yes.
is impolitely propagating a notion that the dances are ops.
Yes, their lordships have held.
Is indecent in the bar,
Yes.
and therefore they should not be permitted to perform where
Yes.
the liquor is served,
Yes.
at a place where the liquor is served.
Yes.
So this is how the apex court has proceeded,
Right.
that these kind of restrictions,
Yes.
an absolute restrictions, not restrictions, these kind of an absolute restriction
Yes.
or a bar
Yes.
is unconstitutional and impinges upon their rights
Yes.
guaranteed under Article 19 of the
Yes,
Constitution.
Yes.
So they say that yes, there can be a check and balances, but it should not be so unreasonable
Yes.
that rendering that particular the restrictions or the conditions
On
to
one
be
group.
to be fulfilled impossible. There is a
Yes.
complete
Ma'am.
impossibility to perform or
Ma'am.
fulfill the conditions. This is what their lordships
Ma'am.
have proceeded on that basis.
Well, for a moment, well, their lordships have also said at paragraph 19 that it is the validity of their lordships, my lords have gone through it. They have said you cannot ban dance performance in IMFL permitted formats per se. Can't say, can't ban it because that violates the fundamental right of the performers as well as enshrined under Article 19(1)(g) and also Article 14, besides the licenses to preventing them to perform their profession. That is also they also have held that under Article 19(1)(g) they cannot be prevented from performing because you have granted them license. You don't grant license, that is different thing. Kindly appreciate my for a moment. And here at paragraph 19 at page 451, the lordships have held it is the validity of these provisions which was the subject matter of the there, my lords, know that the government of Maharashtra, in order to overcome the judgment rendered in 2013, brought out new rules by way of section 33A, 33B, which were challenged, and their lordships held that these conditions now ingrained in the amended statute are nothing different than those which have been struck down by us. So there, here that says, it is the validity of these provisions, which was the subject matter of the appeals before the Supreme Court, as the Bombay High Court had declared these provisions as unconstitutional, being violative of Article 14, 19(1)(a), and 19(1)(g) of the Constitution.
Yes. Yes.
Yes. I'll continue.
Yes, sir.
Yes, I'm sorry, ma'am. It may be noted that
in the writ petitions filed in the High Court, these provisions were challenged as violative of Article 15(1) and 21 as well. However, challenge on these grounds were repelled by the High Court. The High Court had held that these provisions suffer from the vice of arbitrariness and therefore are violative of Article 14 of the Constitution as they provide for different standards of morality to institutions. They had Section 33A, 33B, that activities and the activities in Section 33A. Establishments are less obscene, but nonetheless, the classification bears no nexus to the object of the amendment. It was also held that there is a violation of Article 19(1)A, as dance is a form of expression and the impugned enactment is an unreasonable restriction which is not protected by Article 19(2) of the Constitution. Further, these provisions amount to an unreasonable restriction on the rights of freedom of profession as the state government permitted and granted licenses for running such establishments during res commercium, and that it deprives the bar owners of their right to carry on their profession and bar dancers to carry on their profession. And thereafter,
That was the observation of the High Court.
that is the observation. Yes. And then that has been confirmed by Honorable Supreme Court here. Now kindly have a look for a moment. Even the objectives, the statement of objection reasons, that was which serves as preamble to an amendment to the statute or rule book, that was also discarded by Honorable Supreme Court, that I am placing for a moment. Note 119, that is at page 453. Honorable Supreme Court inter alia held that a perusal of the objects and reasons so that the impugned legislation proceeded on a hypothesis that different dance bars are being used as meeting points of criminals and pick-up points. But their lordships have held, gone into every bit of the pleadings of the Maharashtra government, points of the girls, but the objects and reasons say nothing about any evidence having been presented to the government that these dance bars are actively involved in trafficking of money. My lords, kindly have a look. I'm sorry, I'm taking a little pause. In the instant amendment, the impugned amendment of the rules, my lord will kindly find that is totally lacking. There is no statement of objects, no reasons provided in the amendment of the rules. And what has happened? Overnight, the matter was continuing for grant of license. These were filed, batch of which were filed. That's Commissioner of Excise was sitting over their applications during the period when this amendment had not come up. So they had come before my lords, and this Honorable Court was pleased to direct them to, as earlier on 9/3/2019, this Honorable Court intervened because the rule was made in 2017 for performance of dance, permission to be granted by Commissioner of Excise, that was not given. So the bar owners had come before my lords. This Honorable Court was pleased to grant permission, directed the Excise Commissioner on 19/3/2019. Since then, permission was granted year by year. Only in 2023-24, after issuance of the permission, they stopped it from 1/4/2024 to 24. And then when the bar owners came before my lords, their lordship directed them to grant license within certain time, permission certain time. And during pendence of that, overnight, this amendment of rule has come by obtaining signature of the Honorable Governor and got published in the, you will know proper registration published in the Standard Gazette. That's there. Then their lordships are held dancing a fundamental right. They have said categorically, dancing a fundamental right and not res commercium. At 455 page, my lords, I am placing by only short finding. Likewise, arguments of the state questioning the opinion of the High Court as the provisions to be ultra vires Article 91A and 91G was rejected by this court with the following discussions. That is Indian Hotel Association cases, SEC, that is 2017. That is the previous judgment. Yes, that's 2013. 2013. Their lawsuits have referred to that. A perusal of the objects and reasons show that the impugned legislation proceeded on I have placed it here. So their lordships have held that state questioning the opinion of the High Court as the provisions to be ultra vires Article 91G was rejected by this court with the following discussions. That at note 126, my lord should kindly have a look for a moment. I'm placing it. Yes, sir. This, my lord, will kindly find at page 455. I'm placing it, my lord. Upon analyzing the entire fact situation, the High Court has held that dancing would be a fundamental right and cannot be excluded by dubbing the same as extra commercial. The state has failed to establish that the restriction is reasonable or that it is in the interest of general public. The High Court rightly scrutinized the impugned legislation in the light of observations of this court made in Narendra
That is a
Kumar.
quotation from the 2013 judgment.
Yes, yes.
That is quoted.
Even they have also referred to that, saying that.
No, this is what they quoted
Yes, yes,
in at page 55.
yes.
They have really with paragraph 126 of the 2013
All
judgment
the-
was this quoted.
2013.
Is quoted.
I need not place it.
Yes, that's quoted.
May I place it?
No, no, it's where it is there.
Yes,
It says a fundamental right.
Yes, yes, madam. My lords, during the course of hearing, my lords may kindly appreciate, during the course of hearing, their lordships were pleased to grant stay of the amendment. So that I am just placing for a moment.
Where?
That is at page 459 to 460, 459. At paragraph
400,
paragraph 22.
459 or 69?
459.
59, okay.
59. 59. Paragraph 22 below, my lords. Mr. Jayant Bhushan, learned senior counsel, began his submission with a fervent plea that the respondent state was bent upon banning altogether with a dance performances in the bars, permit homes, or restaurants, etc. His argument was that earlier two attempts of the identical nature made by the respondents failed to pass the constitutional muster.
No. The reason that was a submission. That was
Yeah,
a
that was-
submission of
answer is-
counsel.
My lords have answered that. My lords have answered. That
It
below
says that
I'm
the
talking-
submission was that earlier
Yes,
the identical provision was held to be unconstitutional.
yes, yes.
There was a contempt which was
Yes.
filed.
Mine.
When a contempt application was really set in
Yes.
great motion,
Oh, yes, I absolutely.
then in that event,
Absolutely.
that is they came up with this amendment of 33A.
And their lordships are giving
Then
them.
the court noticed that this is really in the same tune and line, and then passed an interim order.
Determined to put a complete ban. That's what the Honorable Supreme Court realized.
Yes.
And
So that was a submission.
And there are just at 460 middle portion I'm placing. Thereafter, on 26/11/2015.
I have seen the order was passed staying the operation of section 33A.
Yes.
No difficulty.
Yes. Well, not only that, my lords will kindly find for a moment. Their lordships issued a command also thereafter. That I will place for a moment, my lords, at page 471. Kindly have a look. Page 471. I'm placing it, my lord. Paragraph 19, my lord. Having heard the learned counsel for the parties, Dr. Rajiv Dhawan, learned counsel, senior counsel, who sought permission to file an application for intervention, and Mr. Sandeep Deshmukh, learned counsel for the fifth respondent, we are inclined to, there are unimplementable conditions inserted to the statute book. We are inclined to modify the said condition, that is on CCTV camera matter, to the extent that CCTV cameras shall be fixed at the entrance of the premises in question, that shall not be fixed in the restaurant or the permit area or the performance area. Well, that is retired Justice case, Putuswamy case, my lords, no. There the privacy has been discussed in 2017 reported in SCC 2017 volume 10. That also the lords have referred to that. We have clarified the conditions, modified the command issue. I'm missing it.
So what has happened in 2017, again this Indian Hotel and Restaurants Association is that came before the Supreme Court. And therefore, the Supreme Court in that judgment have framed certain conditions. The conditions were that how it has to be done, what restrictions, what precautionary measure one should take.
Even the
Then
railings
there was one of the condition that was condition 12.
Yes.
The condition 12 was that the licensee means these restaurants. They shall ensure that no concealed cavity or a room is created within the premises in order to conceal performances. Reacting to that, the counsel who argues that there is no objection that condition 12 should be retained.
Yes.
And which can be utilized as a green room. Then the order was passed to be utilized in a green room, and a green room must be understood in a very, very classical sense, not to be confused or misused in that sense.
CCTV cameras cannot be fixed there, that is clear wording.
Whatever, that was the Paragraph 13 was that it was argued that the requirement for having CCTV cameras at such places will be a chilling effect, which was also violative of the right of privacy.
Yes.
And this is now declared as a fundamental right.
That is the right of privacy of case.
Article 21.
Case Putuswamy.
No difficulty. Article 21.
Yes.
Right to life.
Yes, right to life.
That imbibe within itself the right to privacy. So that is always there. Right to privacy is also ingrained into a fundamental right. There is no quarrel. There is no quarrel.
There are quoted that judgment.
There is no quarrel.
Not necessary.
No quarrel.
There's paragraph 471, paragraph 35. I'm sorry, paragraph 30 I have said as we have clarified the conditions, the modified conditions along with the conditions on which there is no cavil shall be complied with within 3 days, and the respondents shall issue the license within 10 days therefrom. We are sure the authorities shall act in accordance with the command of this court and not venture to deviate. During pendency, the Lordship had issued this command.
Yes.
So, my lords, now kindly appreciate in the present amendment, first of all, there is no statement of reasons or grounds. Why the amendment is sought for any public good? Well, the amendment is sought for the statute book or the rule book by the state government to be placed before the legislature to make a law for functioning of the state, part of the state or other state. So legislation must comply to the muster of the constitution. Well, that is, my lords know that global energy versus Central Electricity Regulatory Commission, that Honorable Justice Saha has said in the appeal. For a moment, may I place it? How their lordships have held that states have been authorized by the parliament to make legislation of the rules, laws for running of the state, but there must be constitutional mandate. For a moment,
So there is no difficulty. The principle of viris or a doctrine of viris really evolved therefrom.
yes, ma'am.
It says that any law which offends the very core object of the Constitution or is in violation of a constitutional mandate, then that law cannot be held to be a valid piece of legislation. It cannot be held to be a valid piece of
That is
legislation.
what exactly Justice Saha has
That is what is the law.
Yes.
So there's
Therefore-
no difficulty.
Therefore, the Supreme Court has said that it must be the duty of the state to see that. For a moment, I am just short paragraph, please. But my humble submission before my lords is that under no circumstances the impugned amendment of the rule will succeed. Cannot. It's blatantly illegal and alters the constitution. Well, for a moment, I am placing it. It's a AR 2009 Supreme Court, page 3194. The relevant page is 3205, page paragraph 43. The lawsuit how nice is there. I'm just placing it. So, I place it. Yes, please. Epilogue. The law sometimes can be written in such subjective manner, as your lordship was just now pointing out, that it affects efficiency and transparent function of the government. If the statute provides for pointless discretion to agency, it is in essence demolishing the accountability strand within the administrative process, as the agency is not under obligation from an objective norm which can enforce accountability in decision-making process. All lawmaking, be it in the context of delegated legislation or primary legislation, have to conform to the fundamental tenets of transparency and openness on one hand, and responsiveness and accountability on the other. These are fundamental tenets flowing from due process requirement under Article 21. Equal protection clause embodied in Article 14 and fundamental freedoms clause ingrained under Article 19. A modern deliberative democracy cannot function without these attributes. The constitutive understanding of aforementioned guarantees under the Fundamental Rights chapter in the Constitution does not give rise to a mere rhetoric and symbolic value inherent by the polity, but has to be reflected in minute functioning of all the three wings of state: executive, legislature, and judiciary. When we talk, I'm sorry, my problem is there. is talking and reading. It has developed recently. The approach of to writing of law, unless rules, notifications, etc., has to showcase these concerns. The image of law which flows from this framework is its neutrality and objectivity. The ability of law to put sphere of general decision making outside the discretionary power of those wielding governmental power. The law has to, and it's concluding. Law has to provide a basic level of legal security by assuring that law is knowable, dependable, and shielded from excessive manipulation. In the context of rulemaking, delegated legislation should establish the structural conditions within which those processes can function effectively. The question which needs to be asked is whether delegated legislation promotes national and accountable policy implementation. While we say so, we are not oblivious of the contours of the judicial review of legislative acts, but we have made all endeavors to keep ourselves confined within the well-known parameters. A subjectively worded normative device also enables the agency to acquire rents. It determines the it determines the degree of accountability and response in view of officials and of political and judicial control of bureaucracy. However, when the provisions opportunity to consider the propriety and constitutionality of generic decision making process encapsulated under the impugned legislation. Amongst others, in this context, we strike down the impugned clause. Is also there, my lord. Kindly appreciate.
There are several tests.
Yes.
One is the constitutional test.
Mandate.
Constitutional test.
Yes.
That whether it passes the muster of the provision of the
Yes,
Constitution.
exactly. Yes.
This is one.
Obliged.
Another is the reasonability test.
Yes.
That it passes the mandate of the Wednesbury's principle.
Principle.
Wednesbury's principles. That's a test of reasonability. It must pass. And the third object is that what purpose or object it sought to achieve. And the purpose appears to be
Absolutely. I bad. And their lordships are therefore have said that while making
So I was making a broader way that how a
power
approach should be made
laws. Yes.
while testing the virus of a
Right.
particular statutory provision. So these are the certain tools
Yes.
the court must bear in mind
Yes.
to find out whether the virus can be said to be or the provision can be said to be intravirus
Yes.
or ultravirus.
Ultravirus. Right.
This is what.
Yes. One more thing. There are discussed every point, even on the pleadings of the state of Maharashtra on social profile of bar girls is hampered. Their lordships have very clearly and nicely placed it at page 473. For a moment, I am placing page 407. How nicely their lordships have did.
473.
Well,
41 paragraph.
Paragraph 43.1. 43.1. Paragraph 43.1. They have started from 48.
I think the 41 is also.
I'm placing. the reason for the oppressive and moralistic attitude against dance bars, I am obliged to my dance bars takes root from a patriarchal view that women engaging in any kind of work or profession outside the home or domestic sphere carried low social status. And
Anna Markham,
a noted scholar, argues that the
societal view of a bad girls bear close resemblance to the oppressive treatment meted out to a traditional dancing communities.
Yes.
Then they say Devadasis, then the courtesans and the notch during the British era. So this says that how I have seen the noble that particular the dance performance are. And then 43.1 is a social profile.
43.1 social profile of a bar girls. It has been claimed that bar girls are usually minors or victims of trafficking or prostitution and other forms of flesh trade.
Yes.
However, the state government has failed to produce any material, be it crime statistics or any other studies.
That is a factual scenario there.
Yes.
That if you want to put it in such bracket,
yes,
there must be some kind of a data collection, which shows that these kind of a things are the rampant there.
Yes.
The Supreme Court says that there is no data which is
even
coming. There is no material which is coming.
They relied on NDSC report also, who has said that he has supported the dance girls' performance. I am placing it.
This is what the court says. The study conducted by the university and everything.
Yes.
Those reports, they do not suggest that there is any possibility.
Yes. And there also again I have said, on the other hand, this is important, few available historical literature and research studies on bar dance suggest a diagonically opposite point of view. A study conducted by SNDT University, for instance, found that many women performers took up dancing to rehabilitate themselves from exploitative flesh trade. All the above social factors clearly suggest that the bar girls have voluntarily embraced dance bars to live with dignity and kindly appreciate my lord.
And earn their livelihood.
And
earn their livelihood.
Milers. Moreover, the available literature further noted dance bars have had positive externalities on the women performers as it opened newer opportunities and the option to leave exploitative sex work if they choose. But throughout, and even on none of sin, they said it's
an obscene performance. So say
43.2, they have said none of sin performance in any event. This court in Indian Hotel and Restaurant Association reported 2013 they are referring to, and several other high courts previously had categorically held that the performances in dance bars cannot be considered as obscene. The Bombay High Court in state of Maharashtra was a Judge G dealing with the cabaret shows held as under. They have also reported that even cabaret shows can't say that it's obscene because it functions in its own way.
Within the very close four corners of the wall.
The purview of within the limited premises. And lack of reliable data, the lordships have clearly said that it is pertinent for 43.3. It is pertinent to note that there has been a complete prohibition on dance bar since 2005 across the state of Maharashtra. Therefore, the data purportedly relied upon by the state government, it is not only negligible, if any, but also outdated. Be that as it is, the very reason proclaimed by the state government currently have been considered and rejected by this court in Indian. So they refer again to the Indian. They have finally concluded the issue in the previous judgment.
Yes.
And my lords, security, as regards security, every point the lords are discussed, and here in the impugned amendment, in the Excise Act, everything is there. That is why even in the Maharashtra Excise law, the lords have said that you have got enough of conditions, enough of regulations. If implemented, if not totally, you can implement, but there will be some restriction. We can't ban. You can't ban dance performance. My lords, at paragraph 43(4), conditions of work, the lords have held the concerns of the state government that women dancers are subjected to unsafe and exploitative work conditions is entirely false. Various studies indicate that many bar girls felt greater security in the bars due to the support network among the dancers as well as the protection provided by the owners. It was further noted that the bar owners, on the demands made by bar girls, provided taxis and auto rickshaws for women traveling late at night. Although bar girls worked under the constant gaze of bar owners, they are neither contractually employed nor subservient to them. This is most important, my lords. Well, now in the excise impugned, in the impugned amendment, they say you have to make an application, you have to give your ID, you have to give your medical certificate. Well, are they our employees? Come with their free will to this work today, go to the other work tomorrow. They have the freedom of doing that. But wherever they go, the owners of the bar, as my lords have said in the Supreme Court judgment, I will kindly appreciate, they are provided absolute protection. Even they are provided with vehicles to pick up them from their homes and leave them at their residences at a late night, means at 12 o'clock. Because the state government has fixed in the Excise Act that from 12 noon to 12 o'clock in the night for performance, sale of liquor performance. Not beyond that. And even, kindly appreciate from my panel, even the state government excise department has also made a rule that if you want to extend your performance beyond the late night, beyond 12 o'clock till 1 o'clock or 1:30, you pay this much, do that. That is the fees collected. If you allow this, why do you put a restriction and completely ban the dance? How can you do that? But I hope I have been able to apprise my lords with the entire background fact of things. How I don't want to disturb your lordship by placing more pleadings and the other paragraphs. And my lord, you can find even social vulnerability also the lordship have dealt with. Every point in social vulnerability, paragraph 43(5), the lordship have said the prolonged ban on dance bars has had adverse effect on bar girls and women entrepreneurs. Kindly appreciate this. After the ban, the RCWS and FAWS, these are women wings, my lords, study pointed out that income of almost all women was reduced to less than 50% of their original earnings, and at least 1/4 of the women found their income slashed to 90% of their original earnings. At least 57.5% of the women reported having used all their savings in the form of jewelry, cash, or property, and at least 26% of these women have been forced to take additional loans, ranging between the amounts of a couple of thousands and 2 lakhs. The study further pointed out that the access to health care and education of dancers and their families has reduced drastically. Man, you can find how beautiful the lordships have placed it. Moreover, the lack of social security has resulted in sexual harassment and also driven women to take up exploitative sex work. In this background, and contrary to the stated objects, the increased interference by the state government would further jeopardize the livelihood of women. This court in Indian hotel and restaurants, so reported also expressed anguish as a ban on dance bars has proved to be totally counterproductive. Kindly appreciate, my lord. As many women performers were compelled to take up prostitution out of necessity for maintenance of their families. But the state government's duty is to protect their subjects from all wrong. You have categorized them, you have indulged in by bringing this impugned amendment to the rule book. You have indulged in gender bias. It's a clear case. So it's out and out. The impugned amendment is ultra biased the constitution. On morality also, there are lots of I have discussed on morality. On morality, at paragraph 77, we would like to deal at this stage with the argument of morality. As advanced by Mr. Napade, the question is to what extent the state can go in imposing morality and how important it is. My lord, kindly appreciate. On its citizens, in the first instance, we would take note of certain judgments of this court touching upon this aspect. The following report to certain judgments. Paragraph, then note 48. Dealing in a commodity which is not necessary. I will not place it. At paragraph 79 of the judgment at page 493, the Lordship held that it needs to be borne in mind that there may be certain activities which the society perceives as immoral per se. It may include gambling, though that is also becoming a debatable issue now, prostitution, etc. It is also to be noted that standards of morality in a society change with the passage of time. A particular activity which was treated as immoral few decades ago may not be now, so now. Societal norms keep changing. Social change is of two types, continuous or evolutionary and discontinuous or revolutionary. The most common form of change is continuous. This day-to-day incremental changes is performances in dignified forms are socially acceptable and nobody takes exception to the same. On the other hand, obscenity is treated as immoral. Therefore, obscene dance performance may not be acceptable, and the state can pass a law prohibiting obscene dance. That is always there. However, a practice which may not be immoral by social standards cannot be thrusted upon the society as social control. Furthermore, and in any case, any legislation of this nature has to pass the muster of constitutional provisions as well. We have examined the issues raised in the aforesaid context in paragraph 80. This brings us to the principle of res extra commercium. In so far as dance performance are concerned, it has already been held that it is not res commercium. And there was an argument on behalf of the Maharashtra government that this is res commercium, the dance performance is res commercium. For commercial purpose, they are doing. The Honorable Supreme Court has rejected that plea. But this is a little bit important. I am just placing it. Note 119. A perusal of objects and reasons would show that the impugned legislation proceed on a hypothesis that I had already placed before my that different dance bars are, it's not necessary. Well, you will kindly find now. First of all, there is no statement of objects and rejects. How can you make a law rule? How can you make an amendment without a statement of rule rejects? That gives authority to the legislature, the state government, to explain to the legislature that unless you satisfy the general public that for this public good, to achieve this public good, the amendment is being inserted to the statute book or the rule book, that doesn't survive. That itself is ultra vires. Right? Well, that apart, they have also inserted certain unreasonable and uncompliable conditions as sub-rule 5. Minimum 10 conditions. I'll come to that, my lords, because most of the conditions have been discarded by the Honorable Supreme Court. That CCTV camera, they say you have to fix it in the green room, you have to fix it in the dance stage. That cannot be done. And their lordships have also specified in this judgment the railings. What will be the height of the railing of the stage area? Everything is, and that is as per that Supreme Court verdict. Railings are prepared by spending lakhs of rupees for preparing one stage, dance stage. It needs for a licensee to spend minimum 40 to 50 lakhs. Because it requires various kinds of railing will be 3 feet height, there will be a distance. Every regulation is there. There is complete regulation. So there is no absolutely, there is no apprehension or should not have been any apprehension for the state government to impose a complete ban by deleting the word dance. But there is they have filed a counter. In the counter affidavit, my lords will kindly find for a moment.
Counter is in the subaltern.
593.
Subaltern.
Yes, ma'am. Subatom. Next, 3032.
30322.
Sorry. And the counter affidavit, they have.
That is in
They have
30322.
Pardon my.
Counter affidavit has been filed in
Counter affidavit has been filed
30322.
3032 double. My.
In the first item, they have not. In the first item, they have not filed count.
No, first item, no, my lords have dispensed with the account because all the three, subitem 2 are dance for girls. Dance for girls.
With the hard copy.
So the subitem 1 and item 1 and 2 and 3 are liquor licenses.
All are different contexts.
My
All the writ petitions are under different contexts.
Among the 4 writ petitions, 3 are 3022 24. That is 4 dance for girls. They have approached relationships. That their right to perform has been taken away. They have been for last more than 1 year. They have been facing.
So all are not similar.
Pardon?
All are not identical writ petitions.
No, others are licenses. WPC number 501 of 2025, 593 of 2025, and the present one are all licenses. And they have filed the counter affidavit in the first one, that is 3032 3PP. That I am placing before you.
Thanks.
Now there in the counter affidavit, I will kindly have a look for a moment. They have pleaded that the dance for girls, kindly appreciate, dance for girls have not produced any document to show that they are dance perfect. Well, where from the acquired documents? Is it a ground that you want to prevent them? They come from villages. They come from different poor class people that they admitted. And they straight come, and those who are artistic girls, artistic women, they perform dance, could take their money and go back. So that is their first allegation, that no certificate has been from any authorized organization has been placed. And thereafter, they have said they have relied upon take the lead for 2 minutes. Yeah. Matters to kindly appreciate, they have relied upon a Supreme Court decision, that is AR 1977 Supreme Court 722. And in that decision is self-explanatory. My lord, you can find. There they say the state's exclusive right of and privilege to manufacture, store, and sell. Who prevents you to do that? How can that judgment will apply to this Danforth case? Thereafter, one more thing in the other counter, they have said, and this is a constitutional other affidavit, this is the main ground. Dance for girls have not produced any document to satisfy the honorable court that they are.
Is there any organization who can issue a certificate that you are a dance bar girl?
There is no such organization. There is no such organization.
There are organizations who can give you a certificate that you are a acclaimed dancer.
Yes.
A particular form of a dance.
Yes.
One can say.
Yes.
There are multiple.
Multiple nature.
There are multiple types of a dance.
Odissi.
Dance forms. Yes.
Yes. Maybe.
So there are many.
So this is the grounds they have taken. Actually, Supreme Court decision they have relied upon, that is AR 1977-722. That has absolute no application. So only Supreme Court has held that the state government has exclusive privilege to manufacture, store, and sell. We have nothing to do with that. Now, thereafter, in another counter, in 591, my lord, they have said that as per entry number 51, Unit 2, Command 2, 7th Schedule of Constitution, they are
That is within their power to make the law.
power to manufacture, store, same thing under Article 246. I am placing it.
These entries in the 7th schedule.
Yeah.
So far as the state list is concerned, there are 3 lists there in the 7th schedule.
Yes.
3. One is the union list, one is the state list, and one is the concurrent list.
Yes.
So if the entry in the that's a source of power of the state or the union to make the laws.
My lords.
So there is no difficulty. They can exercise their powers. They can make the law, but whether the law which they have made is
I'm sorry.
is in terms of the constitution.
Constitution. I mean, to make law for what? That is provided there in entry 51 and Article 246. Make laws for manufacture the law, manufacture the liquor, store the liquor, sell the liquor, appoint their own vendors or whatever. That is the law. That has nothing to do with this transfer functioning.
No, they have also provided under this Excise Act, to make the rules.
Yes.
And when the rules, they can put a reasonable restrictions. There is no difficulty.
Yes, ma'am.
They can put a reasonable restrictions, but the restrictions should not be an absolute or which offends any of the rights, fundamental rights guaranteed under the Constitution.
I bow down. That is their audit of the Supreme Court also. You must conform to the bust of the Constitution. That's there. Who says no?
Yes.
Well, I think I have been able to satisfy my lord. So.
Yes. Yes, Mr. Advocate General.
May I please answer?
Yes.
There are three things. Let me be very clear. Let's see, have to see that there are, my lord, Justice Raman rightly pointed out, there are two categories of free petitions. I mean, two categories of free petitions. We are filed by the hoteliers, the on-shop licenses, including one which belongs to my non-senior. One thing I had not never be a lawyer for your own cause. Never argue your own case. Yes, very brightly.
What is that? No case, no one case, not one case. They why unless they are making such. I'm sorry. My landfriend is advocate state. I have got evidence. He is a square lawyer. Why should he brings this matter? Whose case is it?
I am bringing new facts. Don't worry.
New fact.
What are the allegations?
My lord, admitting, just a minute. I'm sorry to interfere, government. I'm sorry to interfere, government. I'm sorry. You have made a personal allegation, making personal allegation as a lawyer. My lord, if I
No, I could not actually, frankly speaking, I could not comprehend what he was saying.
Reaction shows that.
No, all that so.
I said that never argue your own case, then why is reacting? I fail to understand.
When I have argued my case, where is my case?
But I did.
Where is my case? If that is the merit of your case, it's okay.
Then he should have, why are you reacting like this?
But who is the owner here? Arguing his own case, that is what is you clarified.
Sir, if you go by a very, very large standard of the law, is there any bar that a person cannot argue his own case? There is a bar.
I am obliged.
He can appear for his case.
All right.
I'm not that.
That's why you have to understand what he really want to say.
These things not very a delegated legislation will not your have to see whether there is an excessive delegation. Whether the legislature which enacted the law, it is well within the competency or offends any of the fundamental rights. These are the two limited grounds on which a law can be declared ultra vires. That none of the grounds here is attractive to assert the correctness of a rule which has been made strictly in conformity with the provisions of the Act. Your Lordship may kindly have a glance at section 20 of the exam.
Mr. Advocate General, can we not also take into account, subject to what he will say, the test of reasonability also?
So that is correct.
No,
that is there very much there. Why this particular amendment was carried out? I am answering one by one. Your Lordship may, before that, I will take your Lordship through the prayer to the appropriate amendment which has been inserted by way of substitution of a particular sub-rule and the other scheme of the Odisha Excise Act, which was enacted in 2008. Your Lordship knows that grant of exclusive privilege is without conditions certain by certain reasonable restrictions. It is not an absolute right. 19(1)(g) is not.
No, it's not. Subject to the reasonable restrictions.
Yes.
19(2) I am conscious. No difficult.
Lordship may kindly come to section 20 of the Act.
20.
Parent
Act.
And then take your Lordship to rules.
This is the rule. That is the.
Odisha Excise Act.
That's yes. It's 20. This is
Law cannot be struck down on the ground with fundamental principle. Let me first, keeping that in view, I will be arguing that it is violative of a judgment laid down in some other country. Your Lordship may be objecting. A law can only be struck down if it is violative of any of the provisions of the Act, provisions of the Constitution, especially fundamental rights. Number two, if it lacks the competency to make the law. Here it is a delegated legislation, whether it conforms to the legislative policy or it is an excessive delegated legislation. Keeping that broad parameter in view, I would be arguing that.
Yes, I understand. Excessive legislation. There is no difficulty.
Absolutely. That's a 20 of it.
Yes.
grant of exclusive privilege of manufacture and sale of foreign liquor. We are on sale of foreign liquor. India made foreign liquor and country liquor or other intoxicant. The state government may grant to any person on such conditions, this is very important, on such conditions and for such period as it may think fit, the exclusive privilege on manufacturing or supplying by wholesale or of both, or of selling by wholesale or by retail. This is by retail and on such conditions. These three words are most completely emphasis, then by retail. Let you see that the mode in which it is to be settled and all that. We have an annual excise policy. I'm not on that. Your Lordship may now turn to section 25 of that. 24. So this right to grant or age as exclusive privilege license is not absolute. It is subject to such conditions as may be prescribed. That would making power. I would take your Lordship to section 90 little later. Your Lordship may now come to section 25 of the Act. Employment of children. That's a particular place.
Yes.
Employment of children or women by licensed vendors. No person who is licensed to sell foreign liquor or India-made foreign liquor for consumption on his premises shall employ or permit to be employed, either with or without remuneration, any person under the age of 18 years in any part of such premises in which such liquor is consumed by the public. No person who is licensed to sell country spirits shall employ or permit to be employed either with or without remuneration. Any person under the age of 18 years in any part of the premises in which such spirit is sold. That is important. No person who is licensed to sell foreign liquor or India-made foreign liquor for consumption on his premises shall employ or permit to be employed either with or without remuneration any woman in any part of such premises in which such liquor is consumed by the public. There is a complete ban here. I will come to the rule. So this is the condition while we are availing the license from the government. This section is there. The virus of neither section 20 or 25 is under challenge before your Lordship may be letting. A particular rule which has been inserted by way of substitution. Few only sub rules, not everything, because all other rules were earlier there. I will take your Lordship to the prayer portion. How it has been vaguely adapted. I will take your Lordship to that. He has challenged the whole rule, sub rule. Only 3-4 provisions have been inserted. I will place the old rule, existing rule, and the amended rule. Your Lordship may admit, there is no challenge to the virus.
So you want to say that section 25, subsection 3
Yes.
creates a complete embargo of an employment or permission to be employed
Yes.
any woman in any part or a premises. So if there is a complete employed or intended or contemplated to be employed, then that particular provision would offend the very purpose of section 25(3).
Absolutely, I'm grateful.
Yes.
This section is not under challenge.
Yes, no, I understand.
Yes.
Yes, not challenge.
Lordship may then kindly come through.
Yes.
Section 90 of the Act.
Yes, sir. Yes.
Let's say close at this juncture, may I, pause it for a moment. There is no dispute that entry 8 of which 2 covers these subjects on which this law has been enacted. So that is not in dispute, it is not in question also. Your Lordship may kindly turn to section 90 of the section 90. Power to impose. It is not a case of excessive delegation of legislative function. The state
It's a rule-making power.
That's it.
Yes.
The state government may make rules to carry out the objects of this act, where not in particular, and without prejudice to the generality of the foregoing provisions, as embodied in section 20 and 25 both. The state government may make rules for this is in addition to, not in derogation of the substantive provision of the act. Your Lordship knows this famous phrase. This is so in particular without prejudice to the foregoing provisions. Your Lordship may kindly turn to Roman 25. Next page at 66, your Lordship is holding this well bouquet.
Prescribing the restrictions under.
I'm grateful. The restrictions, prescribing the restriction under which or the conditions on which any license, permit, or pass may be granted, and in particular, and without prejudice to the generality of the provision, may make rules for, we are concerned with clause C, prescribing the nature and regulating the arrangement of the premises, which is exactly we have done it below, premises, in which any intoxicant may be sold, and prescribing the notices to be exposed at such premises. D. Prohibiting or regulating the employment by the licensee or any person or class of persons to assist him in his business. F. Prescribing
The days and hours during which the license premises. That is the difference.
Yes, prescribe the days and hours to be kept open and provided for the closing of such premises on special occasions. Then prescribing Roman 26 plus prescribing the particulars to be contained in the license, permits or passes granted under this act. These are the occupied areas under which the legislature has conferred power upon the delegated executive to make the rules. So conditions are to be prescribed. Number 1, that is subject to certain restrictions contained under the act. That power has been delegated to the delegate under the law. So the main provision of the act is not under question, not under challenge before your Lordship. So they now challenge the whole rule, which was also earlier there, a portion of it has been amended. Your Lordship may kindly have a glance at the
Are they challenging the whole rules? I don't think so. They are challenging
that is
this
how
the proviso which is inserted to sub rule 4 and 5.
Sub rule 4 and 5.
Sub rule 4 and 5. I was reading that prayer.
Sorry, your Lordship, look at the prayer.
No, they say that why the impugned amendment?
Amendment to the proviso of
That is only to that.
No, the sub rule 5 and sub rule 5 of rule
Correct.
24.
Yes.
Sub rule 5 has been substituted in total. Those provisions were earlier there. Some provisions have been inserted. Your Lordship, yes.
No. So whole of the entire rules they are not challenging. They are simply challenging that portion of the amendment.
But now it has formed a part of the rule. Once it is substituted and published in the Gazette,
Portion. They can challenge a portion.
that is not the prayer here.
That is what is the prayer.
Your Lordship, may read it again.
Please.
I am reading.
Why the impugned amendment
Yes.
to the proviso of sub rule 4 and sub rule 5 of rule 44 of the Odisha Excise Rules 2017
Exactly, that is
called such and such shall not be declared. So this is the only proviso to sub rule 4 of rule 44 And sub rule 5 or rule 44 need not declared as
I'm
violation.
grateful to your lordship. Your lordship may kindly have a
Only
glance.
this one.
No, your lordship may kindly have a glance at sub rule 5. The whole sub rule 5, the whole sub rule 5,
Correct.
which
They
was that has been substituted by a new sub rule.
correct.
New sub rule. And most of the provisions are there. If it goes, the whole thing goes. Your lordship, got it, Mila. It has been.
Let us understand
Yes.
the thing. Suppose the particular amendment which is brought, is challenged, the violence whereof is challenged before the writ court or constitutional court. Suppose the constitutional court held that this is ultra vires. Then what is the effect? That means it should be effaced or erased from the statute book. But it does not mean that what was there prior to the amendment would also get effaced. No, it will remain. So that would be revived. That would revive. But so far as the amended provisions are concerned, those are to be taken off the statute book. So it will not go that there will not be any sub rule 5 that is not there. Sub rule 5 would be there, but previous to the amendment, that would
There
revive.
has to be specific. Your lordship may kindly. These Millard, while granting the license, these conditions were very much there.
True.
Sub rule 5 conditions are the part of his existing license, which has already expired since 31st March. Petitions have become infructuous otherwise, since the virus is under challenge, so therefore I am answering.
Yes.
Otherwise,
We are concentrating on virus. We are not going what is their personal right.
Your lordship may kindly have a glance at the old rule and the new rule. Your lordship make a comparison now. So where the rule has been substituted. Your lordship, I got your lordship's point, but your lordship may most of the conditions stipulated in sub rule 5 are kept intact. There is no touch. But only 2-3 new rules have been amended, which essentially does not amount to either infringing, curtailing, or abridging any of the rights conferred under the statute. It doesn't take away. If your lordship knows that right to run a liquor shop is always subject to the reasonable restrictions, conditions to be imposed by the state, subject to decency, public morality, and all. There belong in Bombay are the whole enactment was under challenge. Here it is not complete ban. We say with the permission of the commissioner you can get it. There is no, we have not stopped the orchestra. You may read the rule, the old rule and the new rule. Very comparison.
I have seen the notable changes.
That's good.
There you have said musical program you have not touched.
Not touched.
The orchestra you have not touched.
Not
But
touched.
so far as the dance programs are concerned or performance,
Right.
this particular expression is deleted.
Absolutely.
It is deleted.
Right.
So their condition is that musical we have no concern. It will be there. Orchestra will be there. There is no difficulty. But the performance of a dance within the bar or a restaurant,
Right.
bar or restaurant,
Right.
or on shop the premises.
Absolutely.
That, according to him, the Supreme Court has said that no, these are all the rights emanating under Article 19(1)(g), 19(1)(a), Article 14, Article 21. All these things have been decided, and Supreme Court has said that you can't put a absolute restrictions.
No, that is subject to same. I am answering that. Exactly will not be same thing.
This is what they wanted to argue. Secondly, they are very interesting and I would say very intelligently the learned senior advocate has put the questions, because he never used the word employment. He consciously omitted in his argument, I am not employing. I will never employ. This podium is open for all and the sundry. They will come, perform and go.
Taken obnoxious.
I do not know. So I have not said anything on that. But please consider that also.
No, he is rather telling that we are sending the vehicles, bringing those cars and leaving them at their house. That is what he submitted, your Lordship.
But this
But
is
that
employment word he never used.
No, that is, Lord, what is this? You bring the girls in your vehicle, employ them or whatever use they. I should not, then what kind of expression should I, Lord, I convey? I do not know. then whether it is employment or I should not use any other objectionable word. So, but the fact remains that those hoteliers or the owners of a liquor shop, pawn shop, they use those girls, employ them or whatever in whatever firm, and Millard subject them to some kind of obscenity for which Millard these raids were conducted. Out of 17 shops, Millard on shops and open on shops in Bhubaneswar, 16 of them, including the petitioner, they were penalized, raided by the excise team. So therefore, after the new government came, we wanted to stop this obscenity. It's not, it is for public good. It is not clearly intended to take away or curtail someone's right to trade. Let them run this shop, but go by these conditions, which the statute imposes. This is reasonable. It doesn't take away the right of a hotelier to question it. I can understand, Milord, if a group of accredited dancers come before your lordship, Devdasi is some other form, Milord, it can be compared. Milord, what should I say? Devdasi is a form of dance which is performed before Lord Jagannath. Should I go further, Milord? I don't propose to go further, then further. That is a different form.
No,
What
that
is
is
it?
what I
It's a
say,
different
that there are multiple forms
Dance
of a
is a
dance.
vulgar form, Milord.
There are
Exposing
multiple.
them to the group
I think
of
Kuchipudi,
drunkards
there is
in
a
open
Odissi,
bar
there are
and
many.
endangering their safety.
Kathak,
Took out of the state. to
Kathak
protect.
and all, I do not know. There are many.
It's my duty, Milord. It's my state's duty to protect, Milord, the chastity of a woman. I can't expose them to some kind of, Milord, vulgarism or obscenity or anything endanger the society by that way. Bhubaneswar is not Bombay. Every local conditions, Milord, your lordship knows from a very city of joy, Kolkata, Lord Park Street, I know the entire city of Kolkata for that. It's different. The culture, the approach, the lookout of the people, everything is this differs from state to state, from region to region, from area to area. It can't be, Milord, the Bombay case cannot be, Milord, applied in toto that this is the case Supreme Court has said. I have the competence, Milord, to make my own law, but it's good for the people of my state. So, your lordship have to test on a limited scope and ambit of the reasonableness, whether it is unreasonable, whether it is unfair, whether it takes away the livelihood of really people those who are seeking for job. Let your lordship knows that prostitution may not be legal, but it is illegal. There is a PETA Act, Prevention of Immoral Traffic Act, which is a punishable act. That is the law in Orissa.
No, it's a central act.
That's correct. We have been following that. We are conducting raids. So therefore, Milord, coming to the point, your lordship may now kindly come to the provision, the old provision and the new provision. What has been really substituted? This provision. The only, Milord, portion which we have deleted is the dance. Engaged in musical program or orchestra in the licensed on some premises.
Only two you are permitting.
That's correct. What is the harm, Milord?
Previously it was dance, but later on you changed it.
Liquor, the whole, what is the purpose? Purpose is if you are taking something, then enjoy if you can, but within the limits of decency.
There are the reports that says that the people's really become so indecent, they become so inebriated in a conditions that they cannot resist or they cannot behave in a very more orderly or a proper manner, where you do not find there must be an empirical data that should be gathered.
That is what compelled us to make this law change. That data frequent.
The only thing which really struck, we wanted to have that clarification. We have seen section 25(3). They have not come forward and challenged 25(3).
That is what exactly I wanted to point
out. They have not challenged.
Absolutely,
we do not want to make any comment from the bench also.
Right.
The employment to a woman is completely restricted.
That's a
We do
separate
not,
domain.
we do
Let
not
us
want to
wait
make
for
any
that.
comment
That's
on
it.
that.
Yes, I got your
Now,
point. Let us.
when a Maharashtra amendment that came, section 33A,
Absolutely. They say.
section 33A was challenged.
Absolutely, I am grateful to your answer. That is the.
Whether the Maharashtra, this act, that's the Excise Act,
Yes.
contained any kind of an absolute prohibition like section 25.3
That is
there.
compare the same thing. I am so grateful that I was going to do that analogy and compare. There is a distance.
Where is that? I wanted
Maharashtra.
Maharashtra.
Lord, Miller, can I reply tomorrow? I have urgent commitment that board. Can I just understand? Please, I will continue tomorrow. I have to attend the meeting at 4. I thought that it would be over. My Lord said it continued for me. Tomorrow at 2 p.m. I have a meeting to be.
You could not anticipate so much of interaction that would come.
Well, I can continue up to 4 minutes. It is that. So I
No,
wanted
that
to
is
be on
what
time.
we also wanted to look at it because these restrictions has really created.
Understand my compulsion. Immediately,
It's virtually my learnment is completed.
No, not completed. I have many things to do complete. Please wait, only a portion.
You carry on.
I am carrying on all right. I am grateful. Your message.
Yes.
I not answers. I have my limitations. I know it. That sorry, your Arship may kindly. Arship have read this provision which has been substituted. I did not read it. Lord, then sub-rule 5.
Let us say CCTV camera and all everything you have put.
Lord, what is new? Let me just the premises. Shall be Lord, let me make one thing clear. 31st March 2025, license is over. Period is over. Every year we come out with a policy, excise policy. The conditions may change also. It is because the policy has not yet come because it is to be tabled and etc. So therefore we have given them 1 month extension. They are on extension. They don't have this right under the old agreement by an executive order. They are being extended with same terms and conditions. So your Lordship is right that this substantive provision of the Act is not under challenge. So at this stage, your Lordship knows questioning the validity of a subordinate legislation, which is strictly in conformity with the provisions of the Act. Maybe more. We have given more what the statute says. So there is a complete ban with so far the prescription of the rule is concerned, subject to 90 sub-rule 2, etc. I was pointing out. So we have given this extra concession also. It is not, it can't be, it's more. This you will see, provided women not below 21 years of age may be engaged in musical program or hold. In the licensed on-sub premises, having a bar license to sell foreign liquor and alcohol for consumption on the premise with prior written permission of the commissioner. You apply to the commissioner that it is to be a regulatory measure. Any person without the identity, etc. Two of the petitioners are from Bangladesh or something like that. Chandigarh and Calcutta. We don't know who are they. What are they doing here? What kind of safety measures? No, that's correct. The safety measures is the duty free of them. One of the bar girls was raped and killed in Cuttack in a hotel. It creates law and order problem for the state to come. We are ultimately answerable for the safety of women and crime against women. It is the state duty to regulate it. Yes, I can understand they have a right to trade under the license, but it is not absolute. You can't do anything which is against the public tranquility, public morality, decency, etc. These are the declarations under the constitution. It's not minor. They say this. So if you have accepted the terms and conditions of a license, you can't claim that no, still I can have it. It's violating of my.
There is no
It's
quarrel.
purely contractual, purely conditional.
No,
subject
there
to
is no
statute.
quarrel. There are certain reasonable restrictions can be definitely put in. There is no difficulty.
Yes.
They can't say that unbundled, I will run up to 3 in the midnight or in the wee hours. That they can't do it.
That they can't do it.
There is no difficulty. That powers is with the state to put certain reasonable restrictions.
Right.
But the only thing is the restriction which cannot be termed to be reasonable.
That's correct.
That is what the Supreme Court was hovering around in that particular judgment and was trying to find out that whether it can be said to be any kind of because indecency was also considered. The Supreme Court really went ahead in that judgment, says that there is no study or a data that came before the court.
But I have come with the data before the last.
So the Supreme Court says that in absence of any empirical data, in absence of any study, and in absence of any research being done or
Your Lordship is correct.
something, so how can you put a restrictions?
Your Lordship,
That is what the Supreme Court says.
No, Your Lordship.
What material we have here in this case?
I'll place those materials. This is all in my affidavit, additional affidavit, counter affidavit, everything is there. Lord, may I read only one paragraph? Lord, this sub-rule 5, may I make a comparison of the old rule and the substituted rule?
We have.
Lord, that's it. I know your Lordship is very sharp that way.
No. My brother is more. Something which
So
I miss,
therefore,
he just point out that this is also there.
I am trying to be as precise as I can. I know I may not read the entire judgments para by para and sentence by sentence. This is on morality, this is on tranquility, this is on peace. This is what I know your Lordship is not in a teaching stage. I have to be very precise and in a capsule form and giving your Lordship. Your Lordship may kindly have at the old rule. What was there and what is. Lord, I have written. Okay. Lord, can I make a comparison tomorrow in a tabular form? What was there, what is new? Only 3 provisions, Lord, are new. Only thing your Lordship may look at yet.
I tell you, there is a difference is in sub-rule 4, what we find the difference is rule 44. The proviso.
Yes.
Where is the amended one? It was here.
Only 2 words.
Yes, I'm giving you amended. No, yes, if you come, I think the sub-rule 4.
Proviso, Lord. Only the proviso.
Yes.
Others are there.
Yes, if you find the language is more or less same, where only or does program,
Yes.
it is omitted, and then previously it was restricted to a police commissionerate of the kata.
Right.
Now you have made it omnibus everywhere. This word you have already.
No, earlier, Milord, this was commissionerate was the only one. Now there are 4 Milord.
So the restriction which was there, this proviso has this.
Yes.
In the police commissionerate Kata and Bhubaneswar.
So that is
That has been deleted.
Commissioner means excise commissioner, Milord.
No, police commissioner.
No, that has been substituted as.
So that is why the notable changes are
Yes.
the dance program, that word is deleted.
Right.
And from earlier it was within the jurisdiction of a police commissionerate Cuttack or Bhubaneswar. This has also been deleted.
By commissioner.
And substituted that you can do it with the prior permission of the commissioner, means commissioner of excise.
Lordship is absolutely correct.
That's true.
Authority, yes.
So this is a notable change.
That's the thing. So it makes Milord, that is the who is to meet the regulatory body to grant license. It is the excise commissioner,
Yes.
the police commissioner. That's a legislative
Yes.
policy. It has nothing to do with the who would be the authority that the licensee cannot decide. That he should be the authority to put the
Yes.
restriction. That is not. It was. But actually, let me see, this pawn shops were only permitted to be opened in Cuttack and Bhubaneswar. In other places, it was not there. Now they have decided to open it in other areas also. So therefore, this police commissionerate word has been substituted by commissioner, which finds expression in the act itself, excise commissioner, or any deputy commissioner designated with the power. Similar, the sub-rule 5, which has been substituted in its entirety. The commissioners shall impose the following conditions before granting such permission, namely, the premises shall be fixed with closed circuit television camera at appropriate places, including the performance stage, and with appropriate mechanism to ensure that the said facilities cannot be tampered with and switched on round the clock. So that this is a regulatory measure to ensure the safety of the women performing the orchestra or music, etc. That orchestra can also be played by the girls. They also sing. It is not completely banned. They have also access to the stage. They can go and sing. But without this dance performance, without has become
Are they not employed?
Yes.
Are they not employed? Then will it not offend section 25(3)? If a woman singer is permitted, are they not employed in the on shop or a bar? Then in that event, there is a complete embargo. You can't permit it. Any woman to enter.
So that is why we are this
Rule
conditions of life.
says women.
Please don't interrupt. Mr. Gajendra, you
There
are
is,
quite
there is, there is,
Please.
there is.
I did
I have
not utter
already,
a single
I have
word.
already noticed
Don't be
that.
angry.
So then what to be done? Then will it not go against the spirit of 25(3)?
The 25(3) doesn't go against pillar. That is against
It
section
says-
92 rulemaking. Power we are giving it
No,
is
no, no,
not.
no. Can you make a subordinate legislation
Just-
which goes contrary to the Parent Act?
No, that
You
is
source
not-
the power, you trace the power from a Parent Act to make a subordinate legislation. Can a subordinate legislation override the provision of the Parent Act? Can't.
Your Lordship is correct. Lordship is correct.
No,
No, your Lordship is absolutely correct. So this has to go in that way, in that spirit, if it is considered, the whole thing has to go, in my humble opinion.
Yes,
I have to check this. Lordship is, I know that.
because there is a complete
correct.
ban,
That's
embargo, that you can't employ women
Milord, that's correct.
Premise,
in the premise.
Your Lordship is correct.
arrangement in premise,
Premises.
any arrangement.
That the whole thing, whole case goes that way. This rule has to also be otherwise declared.
Carve out certain
Milord, I
Elements
do not
from
grant Your Lordship. Your Lordship may grant me a week's time.
Then it has to be looked into that way. The
This I will
permission,
not-
if it is granted,
No,
that means they are never considered
Yes.
to have been employed by the license holder or contemplated to be employed. They just come and perform, and then safety and security is taken, and then it is sent.
Is the.
This is what the purpose.
Of a liquor vendor. Safety and security belongs to the state. It's my duty, Milord, to protect.
No,
So
definitely.
a liquor vendor cannot take charge of the women, make them dance, etc., expose them to vulgarity and say that no, they are my property.
There are 2-3 things
That's correct.
then we'll have to consider in that. If the woman can be permitted to sing along with an orchestra,
Right.
or a woman can perform or can say perform in an orchestra as a part of the orchestra, then one has to understand that with whether they can be permitted to perform within that particular bar. They can't, because 25(3) comes. If we treat it that even a authority, the excise commissioner or the state thought it, no, actually they are simply a performer. They are hired for a remuneration for each day's performance
That
to
is
be.
why they have employed the one engaged.
That is what I'm saying.
That's super.
That is what I'm saying. If they are done, then they are not really employed, and therefore their safety is also their concern, because they are performing within their premises. So their safety is one of the more concerned.
Also the state's concern.
Great. That is what I was saying. So
Primary
they cannot
concern
be termed as an
is-
employee. They cannot be termed as an employee. because they come, perform and go. And it is not an obligation that they have to perform in a particular bar. They may choose to perform in any other bar unless they have entered into a contract. If they entered into a
They
contract,
can be not more vulnerable in my opinion.
if they
It
enter,
is
no, there
more
are, Mr. Advocate General,
That's
there are cases which you will find under the contract, and particularly under the Specific Relief Act. If you look at section 44 or 45 of the Specific Relief Act, there the one of the exception where a negative covenant can be enforced is when a contract is with a singer for singing in a particular restaurant or in a particular program.
That's correct.
He cannot perform in any other podium.
It's correct, Milord. In opera party also that drama is going on in Orissa now.
That is what is the, so they can enter into a contract. There is no difficulty. They can enter into a contract, but shall not be considered to be an employee. That's why the word engagement is used.
Right.
That
It
is
doesn't be not that way offense.
no offense. 25(3).
So the commissioner, let's say the premises shall be fixed.
Yes, sir.
Milord, this is a new provision, B.
B.
Recorded footage of CCTV camera.
Yes.
Made available to the jurisdictional inspector in charge of police station, as well as officer in charge of excise station. But I don't feel what is the wrong in it. Suppose there is a crime. There is a statutory investigation under law.
No difficulty. It's
Is there any difficulty?
it's something which is required. There
Yes, Suppose
nobody can say that I will not.
That's correct. So recently,
Even earlier also, not in that very specific terms, but there was.
there was. That's
That it has to be verified, they have to keep a hard disk.
That I'm just out of context. Maybe also that one incident happened in Bhubaneswar with regard to ill treatment of a girl along with her fiancé, a major, RBB, in one of the police stations in Bharat. That led to lots of chaos. And we had to appoint a judicial commission for that. There was a PIL before this court filed by one of the lieutenant generals. We had to do lots of exercise for installation of CCTV. It was nowhere in any police station. All the 685 police stations, I also advise the government to put it in the police outpost also, because you have Hajat. You can't escape because the Supreme Court has said police station, but the outpost where Hajat is there, you have to put 1,000 police stations, including outpost, Milord. They were installed with CCTV cameras. That is on record, Milord, that there was a PI. So it was, it is our
Very reasonable way of putting it.
That's correct.
I think they can't argue in this way. They are not arguing that
They
also.
are taking exception to this.
No,
Why did-
they are challenged, but their restriction is, entire argument is on proviso to sub 4.
Yes.
They are really concentrated.
Taking exception to the CCTV. There is a challenge.
They have filed a petition, but the entire argument runs around.
It is CCTV cameras. But this is also new. Do
Yes.
not function. It shall be immediately reported to the concerned OIC at the excise station, as well as the police station in which jurisdiction the licensed premise is located. The musical program or orchestra shall be stopped for free as and when the CCTV cameras become dysfunctional. There is no wrong in it, Milord.
Correct.
So we have to keep them what is happening inside there. It's a exclusive privileged area premises. You are being granted with a license to operate that. So therefore, Milord, whatever conditions are embodied in the contract, in the agreement, so that is a form set out for that. You are bound by it. And nobody is forcing you to take an exclusive privilege to run a liquor shop. That is subject to these restrictions,
Yes.
which are considered expedient and just for the public good, to subserve the general interest, tranquility, peace in the locality and area, and women's safety. So the associated hard disk in such CCTV system must have the capacity to store data for a minimum period of 3 months. Because this is a safety measure, because you are knows that if they put the CCTV, do not keep a particular hard disk or the hardware to store the happenings or etc. events.
Normally, any CCTV, they have, depending upon the storage capacity,
That's
of what amount you are spending.
Right.
Normally, up to 7 days means a week, they can restore the entire data. And thereafter, if you want to transfer it, then you'll have to spend more to keep it.
So this
Normally, it remains there for 7 days.
At our home also, data is for 3 weeks. That depends upon the capacity of the
Correct.
hard disk. If it is 2 TB,
Storage capacity depends. It's a 1 TB or
that's it. That's
250 GB is all depends.
You also could find they keep it for 6 months. Because that is for the purpose of suppose any untoward thing happens and then it is subject to a police investigation. They want to extract the data from the hotel system. So therefore, these 3 months, it has nothing to do with it. If they want to run it, put it, do this, then do this. These are the conditions. That the associated hard disk over. So the other provision is the same.
I think, Mr. Advocate General, he has not argued on this sub rule 5. I think we did not have to bother because we will go that this is reasonable. They have not challenged it.
No, they have
It will go.
challenged. Sub rule 5.
That is only in the pleading, but in the argument they must have abandoned.
No, it is prayer.
In the pleading, that is what I'm saying. In the pleading they have, but actually at the time of an argument they have not argued on 5.
Let me request to us. If he make a statement that there is no challenge to 5, then I will.
If he has not argued, sir, we will record that no argument is recorded. That is what I am saying. We will record that not a single argument is advanced.
Advance so far, sub rule 5 is concerned.
Absolutely. No
So
difficulty.
that I will not delve into this area.
Correct. That is what.
So I am only confined to provide.
Absolutely.
Provision to sub rule.
I am only confined to provide. Will I am stupid. So let's see, record it tomorrow at 2 p.m. I'll answer the only provision part. Let it 4:15 for your lordship also.
So,
I can argue for another 15 minutes.
so what? No difficulty.
But I think I am getting more older than you. Lordship.
Yes.
And your lordship, please, your lordship, then I will.
Mr. Advocate General, you will be able to finish tomorrow.
I'll take hardly 15-20 minutes.
No.
If I cite the judgment, it is not needed. I'll give the citation, some relevant paragraphs I'll cite. 3-4 judgments, that would suffice.
Yes. No difficulty.
Right.
More. Even when the BS of the Christian is complete. Good journalism. And good regulation made partial, the partial submission. No, make submission partial. Time fixed with the fit for picking up system tomorrow. Let this matter be listed tomorrow.
Right.
Yes.
Well-
Tomorrow?
Tomorrow, 2 p.m.
Yes, obviously.
Also,
So blessed.
Okay.
Item number 20.
Let's make the lordships. This is that case, my lords. The lordship will remember. Lordship wanted to know whether the commission is authorized to condone the delay. And the lordship also directed me to file all the part. Here is my note of submission.
but audit report.
My lords will be pleased to see.
That can be.
My lords may be pleased to see Annexure A to my written note of submission at page 9. Where the severity has
Have you
specifically
seen,
authorized.
this is 1192B.
Yes,
So whether he has
yes,
power to
yes.
condone.
yes.
We
And
have-
whether
we
the.
have We have passed one judgment.
Yes,
Delivered
I
a
have found judgment.
Yes.
Where the judgment says that it is only a procedural one. And that if there is substantial compliance to that effect, this delay on the ground of technicality should be ignored. I'll first cite the judgment of the Gujarat High Court by Justice Padiwala. I'll cite.
No, we have delivered recently.
You have delivered. My lords have delivered.
No. Action. Action.
803
I'm
35 of 2020.
sorry, man. If our
We have-
own High Court is there, then my lords.
Allowed.
You have the same bench. Why High Court?
That's right, man.
Yes.
That's right. I just
Action.
8035 of 2025.
Yes.
Commissioner has got the power to condone the delay, and that is what the notification says. That is Annexure 9.
This notification we have referred
Yes,
to.
that 18th of November 2024.
We have referred to in the
Yes.
judgment, sir.
Nine. Yes. And the notification says at page 1.1 paragraph.
Mr. Chitrasen Parida was arguing and
Yes.
he has supplied us all material details. These material particulars in his petition we could find and
But
we have delivered the jurisdictional aspect also, which we were posing that day,
but
whether it is board or the commissioner. So by virtue of this notification, commissioner had the jurisdiction
yes,
and he can also has the jurisdiction to condone the delay
Quite right.
also. That's
Quite
that part also we have done.
yeah, quite right. And but some of and other judgments also support my my lord's view that Gujarat High Court and Bombay High Court, they have all supported. They have said that if there is a delay of few days and there is no malafide on the part of the assessee trust to take undue advantage, that should not be a bar in condoning the delay.
Sir, we have already.
That I'm not taking.
No difficulty.
Yes.
So,
Sorry, sir. Much obliged.
yes.
Much obliged.
Yes.
Item 21.
So, initially there is an assessment and order of assessment I have annexed, annexed 2 minutes. And the assessment
was suffering from some error of records. That is, the transaction of 910 was included for assessment 10 to 11. It's an assessment 10 to 15 minutes. But the 910 inadvertently please bear with for some time. I understand. So I filed a rectification.
So he anticipated what you will argue, so please have a patience.
So that is
Well,
what I.
Lordship has already disposed of
No,
one petition on
that
the
is-
same circumstances.
Like, there is a
Or
little
same
difference. That difference that I just I understand what you were. Because I filed a rectification application. This rectification application was dealt in minutes, and the assessing officer found that there is error apart from record. He rectified, even if at the end he writes that it's rejected, but he rectified. Error apart from record, rectified minutes. Plus, I carried minutes revision application before the minutes additional commissioner. Plus, here I committed a mistake, and the authority, while accepting the application, dealing advertising, also committed a mistake because on the last occasion I have brought your Lordship notice, section 81(3) that says once rectification order is passed, that is in respect of the order, original order, which got rectified. So therefore, the order of rectification shall be treated to be an order of assessment which is appealable. It cannot be revised. I cite revision. The revision authority, who has no power to entertain, also admitted and decided and adjudicated. The thing didn't stop there. Because against that order passed by the revision authority, I carried second revision with the commissioner of judges. These are all things that have happened. And the learned commissioner, who is the top hierarchy of the department minutes, he has no power to entertain second revision. The statute never permits it. That is, otherwise the judgment of our High Court is Chief Buddharaja's case. Second revision doesn't apply. That's my opinion. So therefore, second revision was entertained. That was also decided. And the learned commissioner says, without dealing with the rectification application where I have adverted specifically that these are the areas where the apparent mistake lies, but they dealt in and said there is no apparent mistake. That is why I lost before the commissioner. So again, the commission order is now under challenge for Lordship. The Lordship, the last occasion, while taking into consideration the constitutional bench of Hiran Singh's case, that order passed without available source of power in the statute is an origin also. Similarly, that view is also endorsed by a three-judge bench on apex of Guru Sharan Singh and Gurnam Singh. And your Lordship also was pleased to point out that Hobson's case, that also I found the same view was taken. Not only mirrors the order is a nullity mirrors, but all even if appearing in the proceeding doesn't mirrors confer any power to validate and invalidate proceeding mirrors. That also that Hobson's case also Honorable Court has Supreme Court said, and also Hiran Singh's also speaks on same mirrors. So my humble submission here, if your Lordship, is very simple. Now that the order passed by both the authorities, the revision authority in the first and additional commissioner, and subsequent the commissioner are in nullity mirrors, and the matter has not been addressed, which are supposed to be addressed as per rectification application. Those are yet to be resolved mirrors. So mirrors, I have to be relegated to the mirrors appellate authority to file appeal mirrors. But with this observation, unless your Lordship observe this, because I have to take care of the benefit of Section 14 of the Limitation Act, all that will there. But at the same time, mirrors, the order which is under challenge before Lordship mirrors, the commission, neither the commission nor the additional commission has power to entertain.
No, that I understood.
Mirrors. So with this little observation, Lordship relegated. In the last occasion, the anti-tax matter, the Lordship have also relegated, but your Lordship have not observed anything else. Your Lordship in the last occasion have seen the judgment, Hiran Singh, Gurnam Singh, and also your Lordship that Hobson's judgment of our
there, sir. And I admit, I concede the commissioner has made the mistake.
Yes.
Because no
Very good.
judgment is required. Section 79(7) itself says that it is not appealable against 79(2). It is appealable only 79(1). So
Correct.
no judgment is required. Your Lordship, the commissioner, the petitioner himself has done the mistake by filing revision instead of filing the appeal. And the commissioner himself herself has attained by your Lordship mistake that she has adjudicated the matter. So both have mistake.
Doctrine
So
means your
admittedly,
mistake.
the limitation section 14 is applicable. So he has to file appeal and your Lordship.
No, we have to record his submission.
Your Lordship
Correct.
also. Your Lordship.
We have to record his submission. and then relegate him to the appeal,
Correct.
then he will get some.
Your Lordship, what can I say? My commissioner has done the mistake and when the statute is very clear. I admit, Your Lordship.
He is a mischief monger
Your Lordship. But the beginning, the
because
mistake,
he approached.
the mistake has begun by my Lord.
That's why I say.
His class.
That's why I say he's a mischief monger.
Because
Why he approached that particular authority which had no jurisdiction.
Your Lordship.
He was very happy somebody has come before me. Let me decide.
And wrapping fees is not required to be deposited. So in representing fees is required.
That is a doctrinal mutual mistake.
Mr. Sahu.
It is also,
Mr. Sahu,
my lord.
my lord is absolutely correct because the advocate who has appeared before the commissioner, have you marked
I know, my lord. Your lordship knows I also. Well, sir,
his seasoned in this profession?
no, he is pursuing more in income tax matters.
Maybe.
No, he's a very senior person.
Respect.
What I say, sir, he's a very senior person.
More than 50 years of practice in taxation.
Yes,
In
yes.
taxation.
More than 50 years.
Oh. So
But I
in
know,
the
but
entire arena, he is well known.
no,
In taxation field, he is well known.
mainly in income tax side, I know. Because this,
Sir, I had defended him in tribunal, in sales tax tribunal. What to say
particularly
about income tax?
because as your lordship knows, under income tax law, if one doesn't file appeal bench and appeal time has expired, he is permitted to file revision before the commissioner under Article 2, section 264 bench. So somehow or other, that impelled him to.
Great respect. This is not expected. This is a statute.
Anyway, it's a mistake. Is always mistake. Mistake. It's a matter. It's
Not mistake. Let us knowingly mistake.
No, let us
Your
not
Lordship,
take-
only the reason is
Let
that.
us not have that implication. No, no.
Because it is
Because they did not have to pay any of the amount as a condition. We understand.
How
We understand.
How can the additional commissioner at the hierarchy of additional commissioner, they will also commit mistake to entertain the application. But it's a mistake on the part of the petitioner, also mistake on the part of the
No, I did know that the other facet of the coin, when my brother brought it the notice, so I can correlate the purpose and object. Because the commissioner was also of the view, the man of such a high intellectual stature, he will never commit error. There must be something that he has come before the right.
Commissioners taken that ground. Your Lordship, unfortunately, commissioners though taken that ground, that is a issue, taken the issue. But what the commissioner has done,
He was swayed by his aura and the.
Your Lordship, he has decided pass the merit. Then Your Lordship on the last jurisdiction.
I can vouchsafe one thing. I know the integrity, explain all that. That is the.
No, it's not the integrity. What are they talking about?
So Your
It's
Lordship,
not a question of
We
integrity.
all respect
It's a
him.
question of trust and belief.
It's a mistake, in fact. Your lordship,
It's
I
a
can.
question of trust and belief. Authority also believe and acknowledge the legal knowledge and the acumen. So he can never doubt that he may commit mistake.
even
So he proceeded.
even my Lord,
Authority in the order has mentioned this is a revision directed against order passed on 1792. But authority himself writes, which is not mirrors flowing through statute mirrors. It's a mistake. I can vouchsafe mirrors.
Mistake is deliberate or mistake is unintentional we are not entering into that.
Absolutely.
But don't defend. When my brother pointed out, then don't defend.
So we all respect him. I'm not.
Your Lordship, I'm
not questioning his acumen.
Yesterday, even my commissioner, an IS officer, my commissioner has telephoned me and obtained one opinion that even in spite we have no jurisdiction, but senior counsels are coming from outside and from Odisha, and they are focusing their argument on merit. So shall I go both on jurisdiction and merit? I have opined that once you have no jurisdiction means you stop there.
Exactly. Right?
Your Lordship, yesterday only, Your Lordship, after looking into this order, I have astonished, Your Lordship.
Yes. Brother.
I'll pass.
My lords, okay.
Just
Yes.
Item 22.
So also, all aspects we are taken.
Not necessary. My lords,
No, I avoid because if I write, I may curtail many of the rights. So it is better relief oriented.
My Lawrence Senior, I have played. He can convince the appellate authority. So perhaps what is the reason of the delay? Your Lordship, so there is the requirement of the finding.
What's the observation? No,
Yes.
22.
Petitioner challenge the assessment order annexure 1 is the provided work contract services to government of Orissa and various departments. In own assessment, he paid the tax. He paid the tax and intimacy department. He paid the tax on 6 September 2022. I intimated to department and department also acknowledged the
Yes.
acceptance of payment made by voluntary by the petitioner. But after 2 years, and in the year 2024, have taken that 74 proceeding for interest and penalty, ignoring the amendment brought by the Finance Act and board instruction.
Yes.
I want.
No.
Similar matter we have.
Yes, they have already
Admitted.
Today is the matter,
We have
after
admitted.
payment of tax, 2 years.
Sir, similar matter you are doing, no?
Yesterday, yesterday.
Yes, we remember after
But
this.
difference that, with this case, they paid tax before issuance of so-called notice. After 3 years they taken inside the
So
process.
there also voluntarily somebody.
Voluntary paid also. That
And
difference of.
interest and penalty was levied. So. Uncount personal.
Interest is not payable because.
No, you are the counsel there, then. You are the counsel.
Yes.
They have arrested.
4804 of 2004.
We admitted it.
Yes.
You wanted to take instruction. Interest cannot be levied.
Levied, you have to take instruction. Yes.
कितने नंबर दो ना कि
4804.
हाँ जानते हैं तो दो ना कि अपलोड है वो फॉर यही नहीं कहेंगे verify and tell. We know it is uploaded. You see?
Yes, this is what. This is what. From where? So how it came? We don't have a separate system. Yes.
Same.
Yeah, same.
Same date, 18 June.
Upon that, Umesh Sahu, CGC for CGST. Panel counsel for CGST. कौन लिखते हैं? Junior counsel, not senior panel counsel. Junior standing counsel for CGST.
Item 23.
Challenge under annexure 9. It's a
Premature?
consultative order, annexure 9 minor. It is a consultative order for multiple years, your lordships.
Oh.
This case can have controversial your lordship's view. But one, they are subject to your lordship's time acceptance. Yes, the case, my lord, the petitioner admits its tax levy. The leviability has no, he has admitted no.
So these are the questions we will consider on the facts.
Yes, my lord. My only prayer is, let him deposit the tax amount,
The penalty and interest amount may be shared.
Sir, my lord,
Sir,
there is two mechanism here also. Mechanism
Because-
section
No,
7,
if whatever, forget about it.
my lord.
If you have admitted that yes, there has been tax liability. So to the extent of your admission, you deposit, that is what the government says, and stay all the
My lord,
penalty and the interest.
the tax has not been paid by the NHI bylaws. The agreement arises also the pre-agreed existing agreement from the VAT period. And till date also NHI is not paying the tax, your lordships.
That is the only thing
It is indirect taxes. These are indirect taxes. This is indirect taxes.
My
So,
lord, I acknowledge, my lord, it's indirect taxes, my lord.
so whether you have received money from other
That's
to
all.
whom you have
I have
supplied the
educated one-
services, that will detain you from discharging your liability.
My lord, I'm not disputing that.
He is advancing the argument which I advanced
Yes, my lord.
when he was a book before bench.
Yes, I am the only executing was with NHI, and NHI till that your lordship not releasing the payment.
Go assert your right, whatever,
This is a case of 74, your lordships.
whatever.
So,
74 or a 73, we will consider at the time whether, but if they say that there is an admission,
Right.
then in that event, we have to pay the tax component, we will stay the penalty and the interest.
Where is the demand?
It is 5.97 lakhs, your lordships. It is big amount for
Where is
me.
it? Which page?
I am individually, lordships.
Which page?
Annexure 9.
Annexure 9, my lords, page 146, your lordships. And the relevant part of demand is your lordships. At page 182, my lord.
183 is the relevant.
Relevant.
180.
Start with
180.
180.
183.
3.
It talks about the
First part.
First.
9 crore 63.
The proposed demand 9.63, out of that 597 is
597 is your actual amount of tax.
The rate of tax was reduced, my lord.
Yes.
पूरा लिखी देगी এটা पूरा लिखी देगा काउंटर बाय 17 जो सब क्या रहेगा लास्ट लिस्ट इस मैटर में এটা रहेगा impediment will remain state for the matter in view of the fact that multiple tax periods have been clubbed together for assessment under section 74. This matter has been taken for getting the response from the opposite parties. However, it is pointed out by Sri M.S.RAMAN trustee, learned senior panel for the CGST, that the petitioner has admitted its tax liability and he is required to be directed to deposit the same. Mr. Chittaranjan Das, advocate for the petitioner, did not dispute this. In such view of the matter, the petitioner shall deposit the demanded tax within a period of
My lord, at one who cannot deposit the entire 5 lakh annuity, this is liability from 17.
within a period of 6 weeks.
My lord, is 6 months, my lord.
6 months.
My lord,
Before that, hearing will be over.
My lord, I can pay
By June, by next date of listing.
my lord, My lord, in liability from 17, 18, 19, 3 years liability, I cannot put.
Whatever you may deposit, let us see. Let us.
3 years liability cannot, at a one go, I cannot pay them, my lords.
I'm not saying one go, you take till June 17, till the next date of listing.
It will hardship me for my lord. It will quite hardship because once they have not paid the tax liability, your lordship, I have to pay.
We cannot divide.
My lord.
We cannot divide.
I cannot pay the
You
entire
go-
amount. Lord, if one go, your lordship, 5.97 is a big amount for me.
Let us-
They have NHA not paid the amount
By-
also to invest my lord.
By June 7, by the next date of listing for you. List is met also. In the event of such deposit being made by the next date of listing, no coercive steps shall be taken to recover the rest of the demand. Right?
My lord, entire amount, tax amount.
Entire tax amount, you deposit phase wise by 17th June. Next date of listing.
And not melody possible for my lord. If 20% I can pay, I can pay my lord, on tax liability. Because it's
20%.
at least 3 years, 1/3 I can pay my lords. Not possible for me. That's right.
You are admitting your entire tax liability.
But it is not disputed. What they have not paid, NHA did not pay the money. I can pay 1/3 of the amount tax liability also.
So we are staying the interest and penalty part. Interest also is automatic.
I'm grateful, man. I'm grateful, but it's not possible. But I have to continue the business. I'm an individual also, my lord. I'm also an individual person.
Smile. What's to continue? Sorry, next.
Set up on receipt.
What?
By 17th, I said. Okay. He's saying that he has Between the tax, he says that 20% why should be only interest and penalty.
Only the leftover method for service also. Tomorrow for method. All fresh admission. There's submission tomorrow first. Yes,